Morning.
One of these words is kind of framed in the back. Something to do with it. Sorry. I'm curious. Does it have like wedding stuff? I just. Yeah, we don't know.
Chelsea, the camera is working.
Yeah, it's just. You guys feel like.
Yeah,
And the sound is working too.
it is.
Yeah,
Here.
I'm hearing you.
Okay, great. I'm just gonna mute us for a little while. I'll figure out the technical stuff. The state runs this like charitable giving campaign for the last 3 months of the year. So all the state employees sign up and I give up site.
And the sound stuff.
People are already working.
Where? I could be the best. Put it in sleep.
Okay.
True. It's happening. Which I know she.
And she wants things for us.
One day ahead of time.
Sorry, what?
No, they're like harassing you. Oh.
We were there Saturday. They were just mentally, so they just.
How's that?
I've never plugged it in that way.
Okay.
Yeah.
Okay. Okay, Ed, can you hear us?
I can hear you. Yes, I'm not seeing the other commissioners. The camera needs to go to the left.
Yeah.
It's just the position of the camera. The camera's on. I can see
We're
you,
just trying to
Barbara.
get it, we're just trying to get it adjusted.
Yeah, no problem.
There we go.
There you go.
Oh.
Okay.
Okay. That's that.
We need a blank. Definitely me. That's yours.
All right.
That's fine. That's your. Yeah.
All set?
All set.
Okay. I'll call the meeting to order. Good morning. My name's Ed David, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I am asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced now. We have additional agendas, including the consent agenda, available in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time. The commission has voted on those cases and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have reviewed and investigators' reports and any written statements, any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium or recognized online to provide the most relevant arguments in the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one, relevant factual errors, two, relevant omissions from the report of facts submitted during the investigation, or three, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions. I will ask that you introduce yourself as you come to the podium. Thank you. So calling the meeting to order, the first item of business is the adoption of the agenda and the consent agenda. Do I hear a motion in regards to that?
Second.
That's all right. It's been moved and seconded. Any discussion? Seeing none, the commission's remote participation policy requires that the commissioners indicate their votes both verbally and visually. So if you would mind saying your vote and raising your hand. If you vote yes, you are in favor. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
And next, our consideration of the minutes of the August 12th meeting. And if folks have had a chance to review that. we would entertain a motion.
So moved. Second.
Moved and seconded. Any discussion? Seeing none. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Chelsea, can you pin
Thank you.
Okay. I have a few things for you. We have an extern for the first time in several years, actually in the office 2 or 3 days a week. They're great. I don't think they are here today. Milo Schneider from Maine Law just started. Fantastic. Very exciting to have that back again after the pandemic. For compliance, we have 2 active cases in conciliation, 2 unsuccessful conciliations, no successful conciliations, no agreements. The only thing I need from you is we are finally dismissing Fagan versus the trustees of St. Joseph's College. They have fully complied with the terms of that settlement agreement. So if I could get a motion to dismiss that one.
So moved.
Right. So if you vote yes, you are in favor of dismissing that case. Commissioner David,
Yes.
Commissioner O'Brien, Commissioner Walker,
Yes.
Commissioner Douglas,
Yes.
Commissioner Sanders.
Yes.
Okay, before I get into the new charges, I spent basically the last month working on our annual report and also our case count for our EEOC contract, and realized that for both of those, for various reasons, we count one complaint against multiple respondents as multiple cases. So for example, if there's a case against 3 respondents, that is 3 separate complaints. That's how the EEOC counts them. That's how we get paid for them. That's how we count them in our annual report. So going forward, that is how I'm counting them for you and these reports, partly for you, so you have a better idea of what we're actually seeing, and partly for me, so I can use these reports next year when I draft the annual report instead of running 18 different reports in our internal database and trying to get the numbers. So we had 56 new charges in August, 28 administrative dismissals. You're going to see 23 private settlements, or 23 settlements, 21 private, and 2 mediations. The 21 private includes 1 complaint against 16, which is why the total to complainants is only $170,500. So that's the new system. Any questions about how that works? Commissioner O'Brien.
So is there a way, not that I want any more work, I'm asking that and say no but is there a way to tell how many cases also?
Like how many complaints instead of how many?
Yeah.
Basically what we're counting as respondents here.
Right.
And you want to know how many complaints?
Well, is that
Yeah.
difficult to do, or is it?
Nope,
just-
I can
Yeah,
probably.
I don't need it right now, but I'm gonna say.
Yeah, and I can tell you that, yeah, like for the predetermination settlements, the private settlements and the MHRC mediation, there were really maybe 8 cases.
Okay.
23, like I said, the 21 private settlements include 1 case against 16 respondents that settled.
Okay, yeah, if it's not any more work, you
No.
just push another button, I'd like to, because I like to know how many's not in the pipeline necessarily, but
Yeah.
what are. Yeah.
Different, and I have had some conversations with the executive directors of other agencies sort of in New England. We all see each other at conferences. And some of them count them this way per respondent, and some of them count per complaint. And for some of them, that makes more sense. MCAD, which is the Massachusetts Commission Against Discrimination, it's such a high number of complaints generally that I think if they were counting per respondent, they would have like in the tens of thousands.
Yeah.
Whereas for us and Rhode Island and Vermont, Vermont's got about 4 people on staff total. So this makes more sense for them. And some of them divide up those cases per, like, a different investigator might have like the B case and the C case and all of that. But mostly what this is about is that the way the EEOC counts them is they pay us per respondent, which is nice for us.
Yes.
But yeah, I can give you both of those numbers. It's not, I run them that way anyway.
All right,
Break them down. Any other questions about that? Okay. litigation, I'd ask that we take an executive session. New business. I got nothing. You know, we're in the quiet time. Which is nice. I know, I shouldn't, but we have, we finished our HUD contract for the last fiscal year. All of that has wrapped up. EEOC is wrapping up at the end of this month, but all we need to do is submit the closures from this, basically from this meeting. We'll be done with that. And assuming there's not a shutdown, we'll get paid for it, and that will be great. And then we start the whole thing all over again, and it will be business again as usual in a month or two. I anticipate that we will be submitting bills pretty soon here. I haven't heard from the revisor's office yet, but we've got 3 bills that we'll be submitting that are pretty minimal. One, it's basically the bill that we submitted last session to change Barbara's position to major policy influencing and to change a couple of references in the statute that don't make sense. We've separated I learned my lesson. I will no longer be submitting a bill that has a fiscal note attached along with anything else. Those get submitted separately now. So Barbara's position will get submitted, the corrections will get submitted, and we're also submitting a bill to have the mediators that we have covered under the Maine Tort Claims Act, so they would be considered employees just for the purposes of the mediations that they do for us. That's so they don't have to pay huge amounts for their malpractice insurance or their life insurance. Any questions about any of that? Ed, can we be in recess for 3 minutes?
Sure. We'll start again at 8:45.
Ed, I think we're ready whenever you are.
I am ready. If everybody else is all set, we'll call the meeting back into session. The first case for hearing is PA 220308, Doreen Stone versus the garage. The recommendation of the investigator is for a finding of no reasonable grounds. Therefore, we'll hear from respondent. And Kit, you usually want to give your preamble about time and such.
So I just want to remind all the parties and council here that everybody, the only names that you can mention are the names of the named parties in the case. Everybody else is confidential per statute, so I would just ask that you refrain from using the names of any third parties or entities. Attorney Aiello, you have 10 minutes. Do you want to reserve any of your time?
Thank you. Yes, I'd like to reserve 2 minutes if I may.
Thank you. Whenever you're ready.
Okay, thank you so much. Chair David, Commissioners O'Brien, Walker, Douglas, and Sanders. Good morning. My name is Kristen Aiello. I need to apologize for my voice. It's not an infectious disease that you hear. It's being mother of the bride at my daughter's wedding on Saturday, when I talk more than I ever had in my entire life. There are reasonable grounds to believe that respondent discriminated against my client because of disability in this case. And I don't say this lightly. I think the investigator in this case was at a real disadvantage because she was not the individual investigator who did the investigation, did the questioning of witnesses, completed the IRC. That investigator left, and the investigator who wrote the report was at the disadvantage of having to write a report and not having asked questions directly and made credibility decisions directly. Which I think is really key in this point because a lot of this case really rests on credibility determination. And so I've submitted a response or an objection to you. I'd like to note that what is in there is what my client submitted. Most of it was submitted pro se, actually. She submitted her complaint pro se. She submitted her reply pro se. She copied counsel's letter and did her reply in red. It was very detailed. Doreen Stone is my client. She's here with her service animal Willow. Doreen is a social worker by profession. She's used to taking information, documenting information. She filed this case less than a month after this happened to her. She remembers what happened to her. It had a profound effect on her. She is a person with a disability. She requires the use of a service animal. Her service animal is Willow. She's had a service dog for almost 20 years. She's very familiar with the ADA and the Maine Human Rights Act. She actually advises businesses on the ADA and the Maine Human Rights Act, and she's very respectful of businesses and making sure that individuals with disabilities meet their requirements to make sure that their dog is individually trained to do a task. So when my client got to the garage barbecue, a very key and very important fact that was not included in the investigator's report is that Willow was wearing a service desk vest. And that's not coming from me. It's coming from respondents' written submission to the Maine Human Rights Commission, where they said she came in with a service animal, or she came in with a dog. The dog was wearing a vest that said service dog. That was not included in the report, which is really important. Key points here that I've made in my objection, but I want to make again. She had the dog with the vest marked service dog. She came up to the host. She noticed that there are people outside with pets, and she was very concerned about Willow being with pets because those pets are not trained. Willow's been harmed before by an untrained dog. She noticed through the window that people were eating inside. There weren't that many people inside. It was a warm summer day. People were outside. So she was standing there with her obvious disability, with her service animal, and she said, "Can people eat inside?" And the answer was, and she's been consistent about this in her complaint for discrimination that was filed less than a month after this case, and all throughout this case, that before she even had a chance to say, "I'd like to sit inside," the host said, "Yes, people can eat indoors, but you cannot eat inside because dogs are not allowed inside." Now, there's a lot of other stuff that happened after that point, including Ms. Stone asking for 3 times to talk with the manager because she's respectful of businesses. She gets that it's a lower level employee. She figures that a manager would be able to address this. Unfortunately, she was denied 3 times, and just a huge pushback, as is noted in my response. It was really by my client directly. So I can answer any questions about that. One key other point is that when my client was leaving, she was upset, she was crying, she got up from the front, she moved from the table with her service animal because she just couldn't stay there any longer. The manager, who's been very clear and very explicit about this, the manager was there and was watching her. This happened in pretty quick succession. And she left, she started to leave, she noticed the manager. The manager was not going in to get, the host was not going to get the manager. Excuse me, the host was not going to get the manager. The host was out there. She saw him watching. It wasn't until after she left that apparently they say that he went and got the manager at some point. Key point, she didn't leave after he said, I'll get the manager, after she asked 3 times. She left because she couldn't stay there anymore because of the way she was being treated. The Maine Human Rights Act provides that people with disabilities must be allowed to be accompanied by their service animals in all areas of a public accommodation where the public and others are allowed to go. This is exactly the case here, and this is exactly what comes out of the Maine Human Rights Commission brochure. The brochure says a public accommodation may not say certain areas of a facility are off limits to people because they have service animals. For example, and again, from the commission's brochure, a restaurant cannot limit all patrons of service animals to one particular seating area. That's exactly what happened here. The host told her no, she begged to talk to the manager. It was pretty awful. I'm not sure, I'm sure that you must have seen that in my response. But the investigation, the investigator's report aired first and foremost by completely omitting the undisputed fact that when my client walked in, the host was aware this dog had a vest on that said service dog. Now, if the host questioned whether or not this was a service dog, the host could have asked those 2 questions. Is this a dog that's individually trained that you need for your disability? But the host didn't ask those questions. The host instead proactively said, you can't sit in there. Yes, people can sit inside, but you can't sit in there because you have a service animal. And so all the other facts that come after that are certainly relevant and important, but that's, if you stop there because the host wouldn't change their mind, you should find reasonable grounds. There are several things that are not in dispute in this case. There's no dispute that Ms. Stone had the service dog that was marked. There's no dispute she has a disability. She needed a service animal. There's no dispute that this restaurant was a public accommodation. The only issue here was a credibility determination, really, on what happened at that host stand. Now, the investigator's report talks about the manager being told that the host was behaved properly or something like that. There's no evidence that anyone was with my client and her service dog and the host when they were at the stand talking. And she was asking about, he was practicing, she couldn't sit inside. The person she was having lunch with had already gone to the table outside. So that was a mistake in the complaint. And again, the report's reference to complainant's mistaken belief that she was being denied indoor seating is completely unsupported in the record. The record clearly establishes that she was explicitly denied indoor seating because of the presence of her service animal. The report's finding that it seems likely that host did not understand that complainant specifically asked to sit indoors and generally asked the question he believed complainant was asking doesn't make sense. Why would someone come up to the host with a service dog, marked service dog with an obvious disability? Why would there be an extended discussion about service animal? You know, my client invoked the ADA several times, and the host was not responsive at all to that. So thank you for your time. Happy to answer any questions.
Questions for complainant counsel?
Good morning
Good morning, Commissioner.
and congratulations.
Thank you.
So just looking at the report, talking about this credibility determination with respect to the conversation at the host stand, right?
Mhm.
Whether or not your client actually asked to sit inside specifically. So there's a statement in the report, it says basically whether or not your client did ask. The host said something along the lines of they usually sit people with dogs outside. and the report says this is not in and of itself a discriminatory statement. Do you agree with that?
If someone says they usually seat people with dogs outside without any other context of the service animal, of the asking for, people can sit inside with an obvious disability, if someone just says that, as a general matter, I would agree with that. But in this context, what came after that was a proactive, but you can't sit outside because of your dog, with the service dog that's marked, with my client with an obvious disability. And if there was no question about that at that point, then why would she be invoking the ADA, saying the ADA requires that people with service animals are allowed to go anywhere in a facility where others go? So there really wasn't, why would someone go on like that? Why would the host not follow up about that if it wasn't clear? And I think there was an issue with semantics here where they're saying that she didn't ask. Well, she didn't ask at first because he proactively told her no. She said, can people indoors? And he said no because, he said, no, you can't sit indoors because of your dog with her service animal marked. Sorry, that was a bit of a convoluted answer, but I hope it helped.
Yeah, but I think Friend submitted some evidence to the effect of they intended to sit outside, right? Isn't that
Yes,
true?
yep.
Do we agree with that?
We do.
Okay, all right. And then she was led to this table outside and she's asked, is the table okay? And she says it's fine. Do we agree with that?
I don't recall in the record if she said it's fine, but I will say that she acquiesced to sit outside. She agreed to sit outside. That is true. She agreed to sit outside because it was futile to try to continue asking to sit inside. She agreed to sit outside, but she was very nervous about the other dogs in the area harming her dog. So it shows that she's a reasonable person, that she was, she agreed, but she was still uneasy, and no one should be made to be uneasy if she wanted the option to sit inside so that her service animal wasn't with other dogs. So she acquiesced. It wasn't fine that she was being made to sit out there, but she did acquiesce. Yes.
Just so I understand your case.
Yes.
I think I understand your argument to be, right? That because of this credibility determination with respect to what happened at the host stand, you're saying that we should be of the view that there's an even chance that your client could prevail. Is that basically what you're getting at here? Yes,
Commissioner. That's the standard, reasonable ground standard, whether or not there's an even chance of prevailing. And I think my client absolutely meets that. This is not a criminal case beyond a reasonable doubt, where you could pick away and say, well, what about this? What about that? There's at least an even chance of my client prevailing. Yes, thank you.
All right, thank you.
Thank you so much.
Commissioner David.
Good morning, Attorney Ayala. So just following up on what Commissioner Douglas just asked you, I take it that what you're saying is the fact that there was a discussion with the host about the ADA tends to show that discussion had to have been triggered and could not have been triggered by anything other than a denial by the host. Isn't that the argument? Isn't that what you're saying tips the balance in terms of deciding whether or not there was a denial?
Yes, Chairman David, absolutely. There was an extended discussion because there was a denial. And during that time, right, the statements made by the host clearly showed that he was not amenable to hearing it. He would not agree to allow my client access to the manager. He made several comments like, I know the law, that's why we provide outdoor seating. By the time right, that, yeah, thank you.
And what force, what weight should be given to the fact that the friend, and that's disputed as to how much of a friend he or she was, got there first and asked for outdoor seating? Is that just a red herring?
Absolutely. Yes, Chairman, it is a red herring because okay, why shouldn't my client, once she got there, she was intending on sitting outside with her companion. But once she got there, she realized there were dogs outside. That changed her mind and made her feel like, I'm not going to feel safe outside with my dog. I'd rather have the option of sitting inside. So just like anyone who doesn't have a disability, who changes their mind when they get to the host stand, they should be able to be freely decide where they're gonna have lunch.
Right. And nobody questions, but what it was a service animal and that the host could see that. He didn't, you said he could have asked, legally could have asked, is this animal trained to help with a disability, which is part of that definition, but he didn't. He saw, presumably he saw the vest and knew what he was dealing with, a service animal, correct?
That's right, Chairman. He saw, not only, it's not just presumed, the respondent's answers explicitly say that when she walked in, and I quoted it in here, when she walked in, it was on at page 2 of their initial answers. It noted that the animal was wearing a vest that said service dog.
Right. I don't think anybody questions that I can see on either side.
Well, I think the problem with that is that it wasn't listed in the investigator's report. So if you just had someone saunter up to the host thing, yeah.
I
sorry.
see.
Yeah.
No, I got it.
Okay, thank you.
Other questions for complainants counsel? I just want to, you'll have 2 minutes. I'm going to come back to you. I just want to, I don't know how many of you saw the message on the big screen. It's possible that this computer is going to restart at 9:06 because that's just the day we're having.
We're on the phone with IT.
Chelsea's on the phone with OIT to try to get them to delay it till tomorrow. If she can't do that, she's going to switch to the other computer. So we may just
Have to take a break.
I'll unmute my computer. We'll just see how we go. So attorney, who's here for respondent? Arvizo? Okay, up to you if you would like to wait and see how we resolve this, or if you'd like to go ahead with your presentation.
Let's get started.
Okay, great. Sounds good.
Thank you so much.
Do you want to reserve any of your time?
Yeah, I'll reserve 2 minutes.
I'll just keep an eye on this in case we need to pause.
Okay. All right. Good morning, commissioners. Thank you for having me here this morning. I represent the Garage Barbecue, which is a seasonal restaurant located within walking distance of Pine Point Beach in Scarborough. As laid out in the investigator's report, this case centers on a complaint made by Ms. Stone, in which she alleged that she was discriminated against based on her disability by being denied indoor seating because she was accompanied by her service animal. As the investigator concluded, there are no reasonable grounds to believe that Ms. Stone was discriminated against based on her disability. And this is based on the fact that the complainant has not made the requisite showing that she made a specific request to sit indoors and that request was denied. By Ms. Stone's own admission in her rebuttal statement to the Garage Barbecue's answer, she asked 4 questions during the course of this interaction, which lasted just a matter of minutes. In her rebuttal, she said that the 4 questions were, are people allowed to sit inside there? Are you aware of the ADA laws? Can you get the manager? And can I have the manager's email address? Those are her own statements. So the issue here really is that there wasn't an express request to sit indoors. There was nothing that the host understood to be a request to sit indoors. He understood Ms. Stone's inquiries to be general in nature, and he responded in a similarly general nature. He responded that they usually sit people with dogs outside. As I said before, this is a seasonal restaurant. The majority of the seating is patio space. It's, within walking distance of the beach. This is an outdoor centric location. I think as the investigator explained in the report, she wrote, in order to establish this claim, the complainant is required to show that she made a request that respondent denied. While the recollections of the conversation between complainant and host differ, even if the complainant asked the question, can I sit indoors? host was credible in his recollection that he understood complainant's questions to be general in nature. And I do want to point out to that point, from what I understand, I attended the IRC. There was an investigator who was previously involved with this, but the investigator who wrote the actual report attended the IRC, as I understand, in a supervisory role for that previous investigator. So the investigator that authored the report was there during the IRC, and I went back and double checked. She did ask questions during it. So she was in a place where she would have been able to make credibility determinations. She was an active participant in that investigation. In terms of the question of, why would this conversation around the ADA laws have been triggered if not for denial of the request to sit indoors? The host understood this interaction to be an attempt by the complainant to educate him on what the ADA laws were and to question him about his knowledge of the ADA laws. Ms. Stone had discussed with the host her role in educating businesses around ADA laws and ADA compliancy, and he understood her series of questions to be somewhat of a test of his knowledge of what was allowed and what was not allowed. Again, going to the point that this was an inquiry that was general in nature as opposed to a specific request to sit inside. I think when you get down to the record evidence, what it shows is Ms. Stone and her friend or companion arrived at the garage barbecue with the intention of sitting outdoors. They requested to sit outdoors. As they made their way to the outdoor table, Ms. Stone asked the host questions about ADA laws and ADA compliance. And then when they arrived at the table, he asked Ms. Stone if the table was fine. She indicated it was. The questions regarding ADA laws continued, which made the host nervous and anxious. And so when he was able to extract himself from the situation, he went and got his manager. And in the interim, Ms. Stone had left. In terms of the factual omissions, the complaint notes in the investigator's report, these facts are largely surrounding the nature of her disability, the tasks that her service dog is trained to perform, her background as a licensed master social worker, and those don't have any real bearing on the essential question of whether or not a specific inquiry or a specific request to sit indoors was actually made. So even adding these facts into the record or into the report doesn't change that grounds for no reasonable grounds for finding discrimination. In essence, the complainant today is asking you to set aside the determinations of the investigator, which are based on affidavits, statements, and testimony gathered during the investigation in favor of her understanding of the version of events. But because the complainant has failed to make the requisite showing that she made a request to sit indoors expressly to the host at the garage barbecue, we would ask that you adopt the investigator's recommendation that there's no reasonable grounds to believe that discrimination occurred here. So with that, I thank you for your time and I welcome any questions you might have.
Yes, thank you for coming today. Candidly, your client's position here is not persuasive for me, really at all. It strikes me that this should have been a very quick interaction between the complainant and the host. The dog is visibly marked. I can see Willow here today. And so that's what doesn't make sense to me. Patron arrives, asks about indoor seating, host visually observes the dog marked as a service animal. The response under the law should have been absolutely wherever you'd like to see sit in the establishment is certainly, you know, where we can seat you. So what am I missing here? You know, that's the piece that I'm struggling with. What am I missing?
Yeah. I think, you know, without getting too much into things, so I think the host testified during the IRC that he tends to take things very literally. And so to him, she asked 10 people to sit inside. He understood that to mean 10 people sit inside. He didn't understand there to ever be a request of, can I sit inside? It was a general inquiry in nature. Like I said, this is a restaurant that outdoor seating is really the norm. It's a seasonal restaurant, you know, it's outdoor for the most part. And they do have an indoor space, but it's not often people sitting there. And so he took her statements very literally and didn't understand if there was, you know, to be inferred a request in that. He didn't understand that.
Does the law require that a person accessing a public accommodation explicitly claim, right, service animal I'd like to access? Is that your position, that the law requires an explicit request invoking the ADA as a matter of public accommodation, or the Human Rights Act to grant access to a public accommodation?
I think it's a matter of looking at the circumstance of the interaction as a whole. So they came in, they specifically asked to sit outdoors. They walked over to the table and the host asked, is this table fine? And she indicated that it was fine. And so within that context, he would have had to understand that there was a reversal there of their initial request. I think maybe it would have been different if they had made that initial, like, we'd like to sit indoors. But to infer a reversal, especially where the friend continued right along and was very adamant that they wanted to sit outside. I think you see in the friend's affidavit, she had very real concerns about the COVID vaccine. She couldn't get vaccinated. And so she under no circumstances was willing to sit inside. So you have two parties within the same party, one of which it has maybe implied a preference for indoor seating, and one of which is very outwardly wanting outdoor seating. And then you also have these, you know, the initial request for outdoor seating, and then the follow-up, is this table fine? And they say yes. So I think in that context, you know, inferring that there has been a switch of what they want is a lot to ask of a host.
Is there evidence in the record reflecting how employees are trained in the law of public accommodation under the Human Rights Act? Is that in the record anywhere?
It's not in the record. There is, in the record, there's a statement from the manager that says that when the host presented to him the situation, that he took a few minutes to review the ADA laws to make sure that he was refreshed on it before he went out to speak with them.
But we don't know, because it's not in the record, whether this particular host had ever received any training in the ADA or MHRA.
It's not in the record. Sure.
Good morning.
Good morning.
Yeah, so in terms of the factual dispute, right, about what happened at the host stand and they're walking over to the table, I'm looking at the complainant's rebuttal statement, right? And what they say is that the complainant asked the host, can people eat indoors? Like, I think we all agree that that statement or something close to that was made, right? And the host says, yes, and immediately followed up with, but you cannot eat inside because dogs are not allowed there. What's your position on whether or not that statement is made? What's in the record?
My position is that statement wasn't made. If you look at the host's statement and the host's testimony from the IRC, there's nothing that would indicate that he made that statement.
Right. And then the rebuttal statement goes on to say, Ms. Stone told host that she would rather be seated inside and that the ADA laws state that a service dog is allowed to go anywhere the general public is allowed. So now she's alleging, you know, sort of right to the heart of the matter, a specific request to be seated inside, even though her friend didn't want to sit there, she was concerned about COVID, et cetera, et cetera, et cetera. Right, and is it your position that statement never occurred either?
My position is if that statement occurred, the host either didn't hear it or didn't understand it. The friend also said that there was never a request to sit inside as well. So this testimony is supported by the friend's testimony as well.
Okay. So if I'm a fact finder at trial and this, I conclude that this statement was made, isn't that a problem for you?
Yeah, I think that is probably problematic, but again, I think it comes down to this was an interaction that happened in a matter of minutes in an outdoor space, and you know, they were on their way to the outdoor table. And so, you know, whether that was communicated in a way that was understood to the host or not, whether it was heard by the host or not, in his testimony, there's no reference to that.
So this last statement here in particular, I mean, is that consistent with complainant's position at the Issues and Resolution Conference, et cetera? You've heard tell this before, it appeared in complainant's report.
Mm-hmm. Yeah, I think her position, I think that she has said that she stated a preference for indoor seating. I think that's how it's been phrased.
Okay, all right, thank you, thank you.
Other questions for respondents counsel?
Great, so we're gonna pause for just a second while we switch computers fortuitously. That
What's
did
that
not
gonna
happen
do
in
to
the
me?
middle of anybody's statements.
Am I gonna have to sign on again?
Okay, and we're back.
Oh, okay. There we go.
Great. Okay. So Yellow has. Good.
Yep, I love the respondents council.
Do you have more questions?
I do.
Okay. Starting on Zoom?
Sure.
Thought we were done? Apparently not.
Surprise. So I'm trying to not be obtuse, but I wonder. Patron presents, asks about indoor seating, has an animal that's marked as a service animal, and apparently didn't understand, right, that folks with disabilities with service animals have a right to access public accommodations any other way, any other member of the public would have access. You say that the interaction took place over a matter of minutes. You said that the host was nervous. Tell me more about why do those facts matter to you when we're applying the law of public accommodations under the Human Rights Act and ADA? Again, it strikes me that, again, it went on for minutes. That seems really odd to me, right? Because it should have been immediately apparent, right? If they're on notice that this person has a service animal, wants to sit inside. Why wasn't the response from the host, absolutely, wherever you'd like to sit, please take a seat?
Yeah, I think because again, what the host understood was a inquiry that was general in nature. I think, you know, he had talked about the fact that, you know, she was asking him, are you aware of the ADA laws, and talking about her experiences as working with businesses to help them, you know, learn about what the laws were. And so he understood that interaction to be an attempt on her part to just educate and to
Do you think that a reasonable person would have understood that? Let's apply the reasonable person standard here. You know, we went down the main street in Augusta, read these facts to 100 people off the street. Is it your contention that the majority of those people also would not have understood this to be a request for indoor seating under the law of public accommodation?
I don't know. I think that there's some disagreement about the tone of the interaction, and the tone that the host has testified to is that it was a very argumentative conversation from the get-go, where he felt like Ms. Stone was almost leading him into some kind of like ADA trap kind of thing. And so he didn't understand this to be like I'm just asking, you know, can I sit inside? I don't feel comfortable out here. He understood it as like, you know, do you know what you're doing or not? And if you don't, like, let me tell you. And also, you know, there was talk about fines for businesses that don't comply with the ADA and whatnot. And so I think he took a very defensive stance in the face of that tone. So I think the tone kind of shifts maybe.
Does that matter though?
I don't know. I think it just colors his understanding of what was being asked.
A moment ago when I asked you about our 100 people right on the street of Augusta trying to assess what would the reasonable person have understood under these circumstances, I think I heard you say, you know, candidly, you don't know,
Mm-hmm.
you know what folks would say about this fact pattern. And I wonder, doesn't that then mean that the complainant may have an even chance of prevailing at trial if you don't know, right? What would the reasonable person have understood in this interaction?
Yeah. But I think at the heart of this matter is the actual interaction between Ms. Stone and the host. And so I think whether or not, you know, 100, you know, people on the streets of Augusta would have understood, you know, this general question to be, you know, a request for indoor seating. The fact of the matter is that he did not understand, he did not make that leap. And that's, you know, I think that's what I keep coming back to. It's whether, you know, 100 other people would have, I'm not sure, but he didn't.
But we know though, right, that ignorance of the law is not a defense of the law. Okay, all right, thank you very much. I appreciate you indulging my question. Thank you. I want to get right to the heart of this.
Yeah. Any further questions for Respondents' Council? Seeing none, thank you. You'll have 3 minutes and 15 seconds when we come back to you.
Okay.
Attorney Aiello, you have 2 minutes.
Let's get back to that interaction between my client and the host, part that I didn't talk about as much. So she goes up to the host stand. She's got her obvious disability. She's got her service animal. She asks about sitting inside. He affirmatively says, you can't because you have a dog. What happens next? She asked for a manager. She said, can you please get the manager to help clarify and resolve the issue? He said, I know the law. That's why we provide outdoor seating. Now I'm quoting from my client, who filed her complaint less than a month after this happened. It was very fresh in her mind. Their reply, which is detailed, came 2 months later, probably 60 days or whatever the response time was. My client happened to her. She was very clear about what happened to her. But she politely asked a second time in hopes of getting the situation resolved. Host defensively asked, do you know the ADA law? So counsel for respondent is right. The host was defensive. He brought a lot of stuff to this that shouldn't have been part of the analysis under the ADA and under the Maine Human Rights Act. She tried to diffuse the situation, said she wasn't blaming him. He was an employee, thought what he is doing right. Host still didn't get the manager. She repeated her belief that he was an employee trying to do what he thought was right. She was really trying to work with him. Host still didn't agree to get the manager. The third time that she asked to speak with the manager, she did add that she wanted him to understand this could be taken seriously. Businesses can be fined for violating service dog access laws. She hoped that by mentioning the fine, he would understand that the seriousness of the matter. Host did not acknowledge at any time her right to access the indoor seating with her service dog. He just said, "Are you going to sit down and eat?" So there was a tone, there was an attitude, and that's not the way the ADA was designed for public accommodations. Just like Commissioner Sanders was suggesting, the law was designed for a very short interaction. It's not like an assistance animal in housing. It's a short interaction that only allows 2 questions for a business to ask. If the animal is
That was your 2 minutes.
oh, at first I thought it was, and then I thought maybe that was something else.
That was your time.
Going through my head. Thank you, and happy to answer any other questions that anyone has.
Any questions for Attorney Aiello?
Thank you.
Attorney Arvizu, you have 3 minutes and 15 seconds. Chelsea, you should be co-host now.
Okay, am I all set to go ahead?
Yes.
Okay. So I think in terms of Ms. Stone's request for the manager and request for the email, I think this again goes back to the underlying argumentative tone of this conversation that occurred on the way to the table and then at the table. In the record is Ms. Stone's friend's affidavit where she says that as we moved from the host stand to the table, Stone continued peppering the host with questions, testing his knowledge of laws. And the host appeared calm, but seemed to be getting flustered and asked if we were fine with the table and if there was anything else he could do. Ms. Stone remained standing beside the table and continued her line of questioning of the host, who seemed very flustered. So it took some time for him to be able to extract himself from that situation, to be able to go and get a manager. And the manager was in the back, doing clerical work. So he wasn't immediately available. And so I think that that's part of why it took, a minute or 2 for him to be able to go and get somebody to help him out in this situation. At the end of the day, though, I think there's a strong basis here for no reasonable grounds based on the fact that they plan to sit outdoors. There wasn't a clear request to sit indoors after that initial request. They were led to an outdoor table. Ms. Stone's companion sat down at that table. The host asked Ms. Stone if this table was fine. She indicated it would. And then he went to get the manager to follow up. With that, I will leave it.
Any further questions for respondents council? Done. Thank you very much. We've heard from the council, and next we'll hear from Jane O'Reilly, who is the investigator.
Good morning, commissioners. My name's Jane O'Reilly, and I will point out, as has been noted, the original investigation done on this case was done by a former investigator who's no longer here. However, as respondents council pointed out, this particular case was done during a training period. It was one of the first cases performed by this investigator. And so as close as you can be on a case without being the primary investigator, I was participating in this case. Not only was I attending the IRC and eventually drafted the report, but I worked with the investigator throughout the case in reading the file and drafting the questions, as would happen if you were training a new investigator. So to that point, my assessment of credibility is based on actual participation throughout the investigation. I'm gonna jump around because that's what happens when you take notes on presentations. But I'm gonna try to address a few of the things that have been mentioned, and then I'm happy to answer questions. I'll start by saying I think the discussion today has really been focused on what the discussion was throughout the investigation. Unfortunately, there were only a few parties to this conversation. There were only a few witnesses to the conversation, and it really came down to hearing the parties' version of events, trying to figure out what occurred during this conversation and whether or not that met the burden of a request for accommodation that was denied. So my finding, and after reading the submissions and sitting with the parties at the IRC, was that despite the sort of, I do not believe complainant's version of events as presented to me was intended to mislead or misrepresentation of what she believed occurred. However, my finding was that the conversation as reported by complainant today and as submitted during the investigation is not what happened. So she approached the host stand, as has been mentioned. Her friend had already gotten there, indicated a preference for sitting outside. She asked a question about sitting indoors, whether or not the host understood that to be an explicit request. I found not, despite the wording that complainant may have used. I couldn't make a specific finding on what the question was. Complainant certainly remembers what she asked. Host remembers it differently. Both presented a credible, presentation of what they remembered, but host understood the question to be about indoor seating generally, responded with what he always says to people who show up generally. We generally see people with dogs outside. And then throughout the rest of that interaction, no explicit additional request was made. The conversation then went to discussions of what the law protects, what the law covers. I think there was probably a little bit of agitation on both sides, given how both parties presented that conversation. Both felt they were maintaining their cool, but I think probably both were agitated. And then when they arrived at the table, the host asked, is this seating okay? And complainant provided it was, removed himself from the situation and retrieved the manager who came out, and complainant had already left. There was, again, we haven't focused a lot on the sort of additional testimony by friend or by the other patrons who were there. When manager did come out afterwards and asked friend and the other patrons, both said, host was professional. He was trying to, see if she needed anything, get her seated, and that there was no sort of hostility on the side of the host. Again, I wasn't there, but based on what I have in the record and the reports of the people who were there, that was the finding that I made in terms of how that interaction went. Couple other things. I think basically it comes down to two different disputes. One, an actual factual dispute about what happened. And I think I disagree with both parties. I don't think I took fully respondent's version or complainant's version. My finding of what happened is a matter of facts for this investigation was something in between. But then also an interpretation of the effect of that conversation. And I think there's, again, a dispute by both parties. Complainant's counsel, again, presented today that the way that conversation went was in effect a denial from the start. I will point out the comments she keeps mentioning, you can't sit here because people like you can't sit here. That was not a finding I made in my report that those statements were made. Again, I think the conversation had a lot of statements in it that went back and forth, but my overall context of the conversation was that, he was trying to help them. He probably got a little bit agitated. There was a conversation that involved him saying something about he knows ADA because of COVID, which again, is not really relevant to what was happening, but there was a misunderstanding about what information was being presented and why. I found in my investigation, the effect of that conversation was not a denial, and complainant counsel here presented that the effect of that conversation was a denial. But I agree with some of complainant counsel's statements today about the conversation itself. Does that make sense? I'm not totally disagreeing with some of the information that's presented by complainant. My reasoning, however, and I can answer.
Commissioner Douglas.
Good morning.
Good morning.
So I'm looking at the rebuttal statement submitted by the complainant, and there's a statement here on page 3 where she alleges that she told the host that she would rather be seated inside. So what do you make of that? That sounds like a very specific request to me.
Yep.
Sort of contrary to what's in there.
Yeah, again, that wasn't heard by the host as he presented it to me in the IRC. If she said it and he responded with the wrong answer, We generally see people with dogs outside, which, you know, in and of itself is not a discriminatory statement. Generally, again, it was a credibility assessment. I mean, absolutely what complainant was consistent in reporting, that she at some point made an explicit request. But the exact wording has changed slightly, and the host presented to me that what he thought he was being asked was about, you know, the friend came and said, we're sitting outside. And then someone, you know, was leading them to an outside table. And then someone else came and she does say initially her first question was about generally people sitting indoors. She said she followed up to that with an explicit request, which I could not find if was made, was heard or responded to in a way that was an effective denial. Does that make sense? So again, if you find differently, certainly, you know, this was very, these aren't my favorite cases where you're really getting into the statements made by all the parties. But in this case, that was just my, you know, based on what I had on the record and the corroborating statements from the friend who was there and the patrons who heard the end of the conversation. You know, that was my finding in terms of what the conversation.
Thank you.
Okay.
Questions for the investigator? Seeing none, thank you, Jane. So we've heard from the parties and the investigator. At this time, we are looking for a motion. There's one proposed finding.
I move to adapt the recommendation of the investigator as reflected in the recommendation section of the report.
Wait, what did you say?
Move to accept the recommendation as laid out in the investigator's report.
You're fooling me.
So you're moving that there are no reasonable grounds to believe that the barbecue discriminated.
Thank you, Commissioner O'Brien. It's been moved and seconded. Any discussion? Oh, Commissioner David, yes.
Yeah, I'm going to vote against that. It seems to me absolutely straightforward that the friend gets there. The friend says we're eating outside. She gets there. She goes to the host. And then what are we supposed to believe? There's an academic discussion. Oh, by the way, sure, you're going to take me outside, but I'd like to know what you know about the ADA. Can people eat inside or not? The host is trying to steer her to the area where he's been trained that that's where they have pets in the summertime. And he knows it's a service dog. He's not properly trained and he rejects her request. We'll see how the vote goes, but that's what I'm hearing here.
Yeah, I think that I agree with Commissioner David. You know, if I were on the jury in this case, I think I would tend to lean towards the investigator's finding. However, there is a consistent, what I've heard from everybody, there's a consistent sort of allegation in this case that a specific request was made and, you know, that, you know, denied. She said, I want to sit inside. And so, yeah, I'll be voting with Commissioner David here.
It won't surprise you to know that notwithstanding my motion to adopt the recommendation from the investigator's report, I think my line of inquiry to both complainant's counsel and respondent's counsel reflects that I'll be voting no as well. I agree with the chair's assessment and with Commissioner Douglas's assessment.
Commissioner Walker.
Larry,
Just gonna keep it, so I'm, just to keep it clean, just to keep.
When the motion fails, you know you're gonna have to make another one.
You're gonna have to do it again.
Well, it's on the table now. We gotta go to.
Apologies for that. I procedurally didn't appreciate that. So.
I intend to make another motion after this vote.
Great. Any further discussion?
Yeah.
Yes, Commissioner
So
Walker.
I'm going to vote yes to support the motion. I am not persuaded at all by Commissioner Sanders' concerns. I do find it 100% on the credibility of the witnesses, and we have an investigator who has, the only one of us that has been with them in person during the investigation, who found that the respondents' concerns were, or their version was more favorable or accurate. So therefore, very close. I mean, it is a determination on the facts, and whose version of the facts are the most credible, and we have an investigator that decided that the respondent's version of the facts are the most credible. So I would support the motion.
Okay. Any further discussion?
I wonder though, even if the host, right, didn't understand that the patron complainant in this matter was making a request, right? Even if that's true, I think a reasonable person, right, when considering the totality of the circumstances, right, reasonable person could conclude that in fact, that's exactly what she was doing.
I
And
think
if
it's
that's true, doesn't then the complainant have at least an even chance of prevailing?
possibly. I rely on the host asking apparently twice whether this table was acceptable. And the response was yes. Now, is that reasonable from the host and the respondent's perspective? On the other hand, respondent's attorney is making the argument that it got heated in their discussion as they're walking to the table. I think it would be fair to ask, well, if it got heated, wouldn't you ask her, or would she prefer to sit inside?
Right, exactly.
Yes,
Right.
I know. Thank you very much.
I think the explanation is going to be that she said the table was fine, even if the fact finder trial believes that, because she'd already been told no.
Okay,
And
I did not
Yeah.
reach that conclusion.
That conversation apparently happened at the post stand.
Yeah.
According to the rebuttal, so.
Okay.
Further discussion? Great. So if you are in agreement with the motion to find no reasonable grounds, you will vote yes. Commissioner David,
No,
Commissioner O'Brien,
No.
Commissioner Walker,
Yes.
Commissioner Douglas.
No,
Commissioner Sanders.
no, with
Okay.
apologies that.
Commissioner David, I understand you have a motion you'd like to make.
Yeah.
I do. I'd like to move in this case that we find that there are reasonable grounds to believe that respondent garage discriminated against a complainant on the basis of disability. And I think then you add that conciliation should be attempted. Yeah.
Second.
So moved.
Okay. So it's been moved and seconded. Any discussion? Great. If you are in agreement with the motion to find reasonable grounds, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Walker,
No.
Commissioner Douglas.
yes.
Commissioner Sanders.
Yes.
Okay, the findings are reasonable grounds. We appreciate everybody's participation. And the commission will send a letter to the parties and the council confirming the result of the hearing. Commissioner David, could we have 5 minutes so that Chelsea can switch the computers back?
Sure. 5 minutes.
Great, thank
5
you.
minutes. So I think we could get going again.
Commissioner David, it's Glenn Israel on the Zoom. The commission hasn't rejoined the Zoom call yet.
Okay. I mean, I see them on the call. It's just that they're on mute, but they haven't rejoined it.
The Zoom on my end says they're connecting to the audio.
We can.
There you go. Now there's a second iteration. So Barbara or Kit, are you hearing me?
Okay.
I know. So-
What was that? That was me
I like
getting
it.
us back on track.
Hey, where you been?
It's that kind of day.
Where you been? Okay, so we'll be in session and we'll call the second case, Sophine Ganmi versus Walmart, E220336. It's a recommendation for no reasonable grounds on both counts. Therefore, we'll hear from complainant.
Good morning.
Morning. One moment, Mr. Gandhi. We just need to get you up on the screen. While Chelsea's doing that, I just want to remind you to please not use the names of anyone who worked at Walmart. Just, you can refer to them by their title. And you seem to have been muted again, so if you could unmute yourself.
sorry.
There. Great.
Okay.
Okay. You have 10 minutes. Did you want to save any of that time?
Yeah, I'm good, thank you.
Okay. Whenever you're ready, go ahead.
Good morning, Commissioner. Good morning, everybody. Thank you for having me here. Okay. So I disagree with the investigator report because there is a reasonable ground for my case.
Did you want to add anything else, Mr. Godby? This is your opportunity to present your side of the story to the commissioners.
Yes, ma'am. So the date of 4/29/2022 was the hire I began work at Walmart with the role of sales floor employment type full-time associate. At this time, at this date and location, I provide the asked document for first day of hiring. At the same time and location for the purpose of identification as required Form I-9 acceptable document. And this was described as 3 lists of documents categorized with list A or B plus C, but Walmart refused to take this document, and I was asked to provide my passport, and they took a copy of my passport. And at this time, I was the only one who asked to provide the passport. Second thing, 4/29/2022, I was present for the first day of hire, and I work from 9:30 o'clock at night till 7 o'clock in the morning. But with Walmart, fourth timing card they provide, it's showing that I work only from 9:30 o'clock at night till 11 o'clock at night. So I report the missing hours, and I work and not claimed, and I did not get paid, and I wait with promising of Walmart to fix the missing work hours and to add it to the next following payment check, but I never get paid for this missing hours of 11 o'clock at night till 7 o'clock in the morning till today. And the reason for not checking or investigating this matter because my national origin. Because if anybody at the same situation or the same case, according to the laws and Walmart policy, they will check it and investigate that matter. After that, I report a death threat on May 18, 2022 to my direct supervisor, night chief, coach, and they provide the conversation of the recording to support my claim. I provide it after Walmart denied the knowledge of my official report and my concern of making my official report disappear and denying receiving any report from me, and they deny even hearing of the death threat I report and the record I use as evidence to prove that Walmart knows presented of my direct supervisor and my night shift team lead, and they should legally hold liable for harassment perpetrated by their employee agent when they fail to investigate and ignore and deny and rejecting receiving a report and fail to investigate and take reasonable steps to prevent such harassment after get promised to investigate. And the reason for not giving any attention for my report when my night shift coach received it first as it's recorded, and secondly as official harassment report because of my national origin, because if the same type of record according to the laws and according to format, code, and policy, the report will be investigated and taking the right legal way of processing. So they profile me because of my national origin, and they take my official harassment report and make it disappear, and they did not take the legal way process to deal with it. After that, I disagree with the investigator because she forget to add the report that I provide at the second record of conversation between me and my night shift team lead, and they provide that record to support my claim of Walmart started retaliation after I report the death threat to my night shift coach by starting cutting my hours, changing my schedule, and claiming that the computer changes the schedule automatically. So I provide for that my first schedule I received first time of hiring, and they provide a record of my conversation with my direct night shift team lead. That I was complaining about someone keeping, changing, and cutting my hours while I was hired a full-time associate. And other record took place. My night shift took picture of my information with the promise to check with the night shift coach, and that providing that someone was changing my schedule, and they claimed that was a first retaliation because of my death threat report. I claimed that I was fired illegally as continuous for retaliation from Walmart because my previous report of death threat, and they provide the document support my claim of my legal leave of absence after Walmart, and they respond claiming the total denied of knowledge of the reason of my leave at first because they don't know that I already have a copy of my claim number and my legal claim steps, and for that reason they use the term abandonment of job, and that will be categorized at different section and type of Walmart policy that's called voluntary termination. And even after the last Zoom meeting, Walmart continue to falsely use part of their policy that's not related to the leave of absence to cover for the retaliation that end with me get fired, not abandon my job. And they use the term abandonment that will be categorized as part of voluntary termination type according to their policy, while they should use the policy of leave of absence, and according to the document they provide of their leave of absence policy, they cannot claim that I abandoned my job, and they cannot use the no-show type of absence because that's different type of absence according to Walmart policy, and that's what make it two different types of absence. Thank you.
Thank you. Any commissioner questions for complainant? Seeing none, Mr. Ganmi, you'll have about 2 minutes and 20 seconds when we come back to you. Chelsea is going to mute you for now, and we will hear from Respondents Counsel. Attorney Powell, are you here for Walmart?
I am. Thanks very much. And good morning, commissioners. Tim Powell on behalf of the respondent Walmart. Thanks for your time today. We submit that that Investigator Leva conducted a thorough investigation here and reached the appropriate decision here. With all due respect to Mr. Ganmi's complaints, there's just no reasonable grounds to find any discrimination or retaliation in this case. So there's 2 counts in this case. I'll go through them each in turn. The first issue, Mr. Ganmi claims a violation of the Whistleblowers Protection Act because he claims to have reported a violent threat made to him on May 18th, 2022. There's many reasons why this claim fails. There's no record of this report being made. It was never reported to Walmart's ethics helpline, to HR, to store management, as he knew how to do. Mr. Ganmi alleges that he received a verbal threat of violence from a vendor, not a Walmart employee, who allegedly visited the work site and made a threat against him, and that he reported this to a coach at the store. This coach is not a member of management or a supervisor. And Mr. Ganmi, after this alleged report, Mr. Ganmi never raised any further concern about this issue to anyone else. As I said, never reported through the ethics helpline, never went to anyone else at store management or HR, and never reported any further issue moving forward to anyone, including the coach. You know, he knew he had all of these options available to him to report. He had just started and been through Walmart's orientation on April 29th, which was, 2 weeks before this incident, maybe 3 weeks before this incident, where all of these, avenues of reporting had been, conveyed to him, and he was trained on them. If a report of a violent threat had been made through any of those avenues, Walmart certainly would have taken it seriously and investigated it, and there would have been no retaliation against him for it. So finally, even if Mr. Ganmi can be considered to have made a protected report under the Whistleblower Protection Act to that coach, there's no evidence of any causal connection with his subsequent termination. His termination was not until several months later, in July of 2022. In the meantime, there was an intervening incident where Mr. Ganmi accumulated a significant number of attendance points, 39 attendance points, that led to his termination under Walmart's policy, and which I'll discuss in a minute. But more importantly, perhaps the coach that he allegedly made this report to of the violent threat was not in any way involved in the termination decision. In fact, he wasn't even employed at Walmart anymore at the time of the termination decision. So he just could not have been part of and was not part of the termination decision. And there's no evidence that this coach ever communicated anything about this alleged threat to any of the decision makers that made the decision about the termination. So there's just no causal connection here either between any protected report and the termination decision. The second issue in this case, Mr. Ganmi claims his termination was discriminatory based on his national origin. And again, there's simply no evidence for this, as the investigator noted in her report at footnote 2. Mr. Ganmi's evidence for this is simply that management knew he was from Tunisia. Management did know of his national origin, that he was from Tunisia at the time of his hire, based on his passport, as he says, that he was provided at the time of onboarding. Yet they hired and onboarded him at that time, knowing his national origin. It makes no sense that after hiring Mr. Ganmi with knowledge of his national origin, that 3 months later, these same people would then turn around and fire him on the basis of his national origin. And there's really just no other evidence at all in this case, other than just speculation that the termination decision was based on his national origin. Now, Walmart terminated Mr. Ganmi's employment because he stopped coming to work, did not call in any of his absences, and simply abandoned his job. At the time of his hire in April, which again was about 3 months earlier, Mr. Ganmi was notified of Walmart's attendance policy, which required him to report his absences to store management. And each absence resulted in 1 attendance point, and each no call, no show, which means not calling when you're going to be absent, results in 2 attendance points. And Walmart's policy is very clear that associates who accumulate more than 5 attendance points in a 6-month period are subject to termination. Now, this applies even if an employee has made a leave of absence request that is pending. And the reason for this is Walmart uses a third-party leave administrator. So even if a leave request is submitted through that third party, the store management still doesn't know whether someone's going to be out. And so the policy is that the associate needs to still communicate to store management when they're going to be absent. And the investigator here correctly concluded that Mr. Ganmi knew Walmart's attendance policy. He knew that he was required to call in any absences, and he knew that accumulating more than 5 attendance points would result in termination. And I will say this is not just an obscure policy, buried somewhere in a handbook. This policy is covered in onboarding training. It's well known to associates. And frankly, it's a very common discipline and termination issue for Walmart to be dealing with these and managing these attendance point issues. So on June 17th, 2022, Mr. Ganmi left work early and never returned, never told anyone why he was leaving, never called out for any absences in the following days. And he accumulated 39 attendance points, far more than the threshold for termination. And so on July 3rd, the store management terminated his employment. And Mr. Ganmi provided some evidence that he had requested a leave of absence from the third-party leave administrator, but he didn't follow the policy for calling out any of his absences. Store management had no idea he was absent or that he had even made this leave of absence request, and that's precisely the reason for this policy of having to notify of your absence. And finally, Mr. Ganmi's claim is that his termination was either discriminatory based on his national origin or retaliatory based on his alleged protected safety report. And there's simply no evidence that either of these factors was the motivation for termination of Mr. Ganmi's employment when he was a repeated no-call, no-show through the end of June 2022. So for these reasons, I respectfully request that the commission vote to uphold the investigator's finding of no reasonable grounds, and I'm happy to answer any questions that you have. Thank you.
Any questions for respondents, counsel?
Yes.
Commissioner David.
Attorney Powell, does the record reflect whether he is ever paid for the overtime, even after termination or final check or whatever?
Yep. So the pay issue, it may be a misunderstanding on behalf of Mr. Ganmi, but he's been paid for okay. All time, that we have time records of. He has certainly been paid for that. Something we went through in our investigation when we received this complaint. And I know he had made a complaint at the time, and they did the same thing and went through it with him and showed that he had been paid for all hours that he worked. Thanks.
Right. I am concerned about the leave of absence request. You said that they didn't even know. That's a little hard to believe that they don't even know that he's made the request. I can understand that the request has not been acted upon by the time he leaves.
Yeah.
The investigators said that the request was for a leave with an expectation of return to work July 6th, and he's fired on July 4th. Is there any flexibility in the policy? I mean, we have a situation here where he says he's called to Tunisia because of a death in the family. Mm-hmm. I don't know if the record reflects anything about ability or cost to communicate, to call daily from Tunisia, or what the infrastructure is to do that. So the question is, was the leave of absence ever granted?
No, it wasn't, is my understanding. I mean, I think, I believe there was an issue with getting documentation to support it. And so I don't think the third party administrator ever did approve it, but it kind of.
So he did. I mean, the documentation that's missing is that he's gone and he's in Tunisia, right?
Well, documentation to support whatever the leave, and I don't know exactly what the reason for the leave request was, but documentation was required in order to support the need for the leave and to be approved by that third-party administrator. And I don't think that process ever did occur. And
okay, I mean, yeah. the investigator found, Attorney Powell recites that the request was because of a death in the family and that he left to go to Tunisia. So I'm assuming that the statement that there's no documentation is because he's gone. I mean, it sounds like a rigid policy that one would hope there was some ability for discretion. But I hear you. You say
Yeah.
the answer is no. They never acted upon the leave because he failed to submit documentation. So
That's my understanding. And then, so the other issue then before that is that, the store itself is not aware of this. He's not provided any information that he's going to be absent at all, or what the reason is. He went through the process through the third party as he is supposed to, but the store management had no knowledge of this as well. And I guess a last point is,
isn't it reasonable? Isn't it reasonable for him to assume that going through the correct process and filing for the leave of absence is notice to the store that he needs a leave of absence?
Well, not according to Walmart's policy. They specifically ask for, as the investigator found, they specifically ask for notice to be also provided to the store management. And
Okay.
I just want to make one additional point, if I may, that respectfully, this is not a claim here about failure to provide the leave or anything to do with the leave request itself, which was being handled by the third party. It's there was no investigation really down that path of that issue. The complainant here is alleging discrimination based on national origin and Whistleblower Protection Act retaliation. And so we submit, even aside from the leave issues that was going on, that there's no evidence here of that national origin discrimination or the whistleblower retaliation.
Thank you.
Commissioner Sanders.
I think I read in Mr. Gomney's rebuttal that there was some difficulty ongoing, notwithstanding the fact that he was hired as a full-time employee, of getting on a schedule, either regularly or, there was some question about fewer hours that he was expecting. I think I read in Mr. Gomney's rebuttal that after he notified the third-party administrator of the need for leave on June 16th, that he was not thereafter placed upon the schedule. Is that right, Attorney Powell?
I'm not sure, and I'm not sure that's in our record here for me to be able to discuss anyways, but I believe, if that is the case, it would have been because he was absent he was a no call, no show from that point, from June 17th, I believe, is that he left early on June 17th. He makes the leave request to the third party on that same day, and he's a no call, no show for the next, several weeks. And so they may have taken him off the schedule because, of these attendance issues. He would have been eligible for, he would have hit the 5 attendance points issue pretty, within a few days of being a no call, no show.
Sure, but if it's true, right, that he initiates the leave on June 16th, and if in fact he was taken off the schedule immediately thereafter, what would be the rationale for him to continue to call into the store to apprise the store that he was absent, right? If he's not on the schedule, store management knows he's not coming. So I'm trying to help me understand.
Yeah, and I'm not sure. I don't know if I can specifically answer the question because I don't believe I've seen the schedule, whether that's allegation is true, and I don't believe it's in the record. But really, the issue is there was no communication of any kind. It's not, even his initial departure wasn't even notified to the store. So he's from the store management's. Not as far as the store management is aware, he has abandoned the job. I understand he has a separate claim, and he has the leave of absence request that then gets made to the third party. But store management, they only know of the fact that he's a no call, no show, essentially.
I understand that. Thank you. I guess my point though is that if he's off the schedule immediately thereafter, he never would have accumulated enough points, right?
Oh, I see. I see. Yeah, and I'm not aware. I don't believe that that's accurate, and there's no evidence that that's the case, that he's been pulled off.
We'll ask. Yeah, well, I'm happy to ask the investigator. So thank you for that.
Yeah.
Further questions for respondents, counsel?
Can I answer?
Oh, Mr. Gomney, 1 minute, please.
Okay.
Attorney Powell, you'll have about 2 minutes and 15 seconds when we come back.
Okay, thank you.
Mr. Gomney, if you would unmute yourself, you have 2 minutes and 23 seconds if you'd like to respond to what Attorney Powell said.
Okay, sure. Thank you. So about the Walmart not knowing about my death threat, I have a record I provide you guys. I have a conversation with the night shift coach about someone threatening to kill me, death threat. And the next day, I provide official report, but they make it disappear. And they, right now they're saying they didn't hear about the report. Second point, the leave of absence, the information, I get advices from the manager and the night coach to go to my Sadwick and do the report, do the claim. And they did the claim, so they know I'm going for emergency. So they advised me to do the report through my Sadwick. That's the first point. Second point, with the document I provide, the leave of absence have a date to start, and they contact me in with the document I provide 6/29/2022, and they ask me to provide a document for the situation of my father. That's the reason for leaving. And I provide the certificate from the doctor from Tunisia. So they know, they ask me about the document and they provide it according to the document, to the proof I give to you guys. That's it, thank you.
Any questions for Mr. Gandhi? Seeing none, thank you very much.
I'm sorry,
Sorry,
just
Commissioner
one-
Douglas.
One question, yes. Good morning, sir. I'm just curious. Did they ever, to your knowledge, identify the specific individual that you claim made a death threat against you?
Sorry, can you repeat that? I'm sorry.
Yeah, I'm just wondering if, did they ever identify the specific individual that you claim made a death threat against you? Do you know if that person was ever identified?
No, they never check the camera. They never provide me the name or any information about it. Even they promised they will investigate, but they never investigate. They never took any action or do anything.
Right, but when you spoke with your night coach about this, the coach, he didn't know who this person was. Was that your impression?
Yes, he know. Yes.
Okay, all right, thank you.
Yeah, thank you.
I do have a question.
Yep, Commissioner David.
Yeah, Mr. Gandhi, did you just tell us that you provided a document about the death of your father in Tunisia, that you provided a piece of paper or a doctor's note or
Yes,
something to
sir.
them?
Yes, sir. I already provide you guys the paper in 6/29/2022. Walmart, through my Sadwick, they emailed me and asked me to provide the doctor certificate, and I provide the document.
I just want to be clear for a second, because we seem to be wandering down a road that we don't belong on, which is that complainant never claimed that the leave was discriminatory in any way, shape, or form. So I'm hearing a lot of questions about why he was denied the leave and what that was for. And there is not a claim in this case that he was denied leave because of his national origin or because of his whistleblowing. That was an intervening issue that seems to be the focus. So I just want to redirect folks.
Any further commissioner questions for Mr. Gandhi? None. All right. Thank you, Mr. Gandhi. We will hear next from Powell. You have 2 minutes and 13 seconds.
Oh, there we are. Thanks. So just wanted to make one point, and thank you for the clarification. Yeah, that this case really is about the claims that were made were national origin discrimination and Whistleblower Protection Act retaliation. And there's just, there's no evidence of any of that being of any discriminatory or retaliatory animus being the basis for the termination decision here. And so I urge the commissioners to uphold the finding of no reasonable grounds, and happy to answer any other questions.
Any commissioner questions for Attorney Powell? Seeing none, we've heard from the parties. Next, we'll hear from Investigator Leva, the investigator assigned to this case.
Hi, good morning, investigators.
Commissioners.
Commissioners, I'm sorry. I'm hoping there's
It's a day.
not an echo. I'm hearing an echo on my end for some reason, but it just could be my office. I mean, the facts are simply laid out in my report. There was an intervening act between the report that he made with the protected activity and his firing, which is why I found that the activity itself wasn't the reason he was fired, and also that he was unable to provide any sort of connection between his national origin and his firing. So those two also were not connected for me. He also did make a claim about religion discrimination that was inadvertently left off by me, but that would have been no reasonable grounds as well, because there was no connection between his religion and either his ultimate termination or, being anything in the case for that matter. But I'm happy to take any questions if y'all have any.
Questions for the investigator? Seeing none, thank you, Nooper. We've heard from the parties and the investigator. At this time, we will be looking for a motion. There are two proposed findings. Brian.
I've taken together and say and agree with the report that there are no reasonable grounds to believe that Walmart discriminated on the basis of national origin or retaliated for engaging in Maine human rights or WPA protected activity, and complaint should be dismissed.
Can I make a suggestion? Because Nooper did just mention that there was a box checked for religion, and it was never mentioned again, but I think we should add that to the no reasonable grounds finding. Would be interested in amending your motion.
Yes, I would like to amend my motion. There are no reasonable grounds to believe that Walmart discriminated on the basis of national origin or religion.
Thank you.
Do I have a second? Walker. It's been moved and seconded. Any discussion?
Yeah, I mean, I would just briefly say that I think we can take issue with Walmart's leave of absence policies all day long. Their decision to sort of farm that out to a third party administrator and what predictably happens. But I don't see any discrimination in this case.
Any further discussion? Seeing none, the motion is to find, no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David.
Yes, but I don't like it.
Noted. Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Okay, so the findings are no reasonable grounds. We appreciate everyone's participation. The commission will send a letter to the parties and the council confirming the results of the hearing.
And the next case is E230031, Karen Haley versus Maine Health. It is a recommendation for no reasonable grounds findings on all three counts, and therefore we'll hear from complainant.
Good morning. Great, thank you, Ms. Haley. 1 minute, let us pin you. Okay, you have 10 minutes. Do you want to reserve any of your time?
2 minutes.
Whenever you're ready, go ahead.
Okay, and it's Carrie, just to make sure. I'm here because the commission's investigator didn't accurately capture my experience, and Maine Health has never produced any proof that refutes my claims. They just deny my experience. But I can say who does agree with my experience, and that is my doctor and my therapist. My symptoms were very real, and they were caused by the hostile work environment that was continually allowed by Maine Health. The crux of my experience is this. I reported my manager's discriminatory behavior directly to her in hopes that she would see her bias and change course. Since she didn't, I collected that data to prove my claims, which I sent as proof to the commission and to Maine Health. What happened next would have any reasonable person seeing the truth of what was happening, because it became so blatant. I want to make clear that I've never had any performance or attendance issues while employed with Maine Health, but my manager would go on to try to manufacture an attendance issue to try to get me fired because I reported her discrimination to our COO. My department had successfully been working from home since 2020. There was no return to work mandate by Maine Health or my department. We were asked to come into the office on the first Tuesday in January with no reason given, and the request was for Tuesday only, proof of which I've already provided. My male coworker didn't come in that day due to an illness, but he was permitted to work from home and was not forced to use PTO. We were then asked to come in for the remaining days that week. He was still permitted to work from home, so I was the only one going into the office. And when I asked my manager if I could sit next to her to train on the new system, she said no. So this was not about training, not to mention I also submitted proof that we had already done our training remotely. The day that I sent the email to the COO to try to get an in-person meeting with her, to tell her the full scope of my experience, she forwarded that email to the manager that I was reporting on, enabling her to retaliate against me, and she did. She pulled me aside that day and told me that specifically based on a line in the email that I sent to the COO, she was no longer approving the already approved PTO I had for that afternoon, and said that if I couldn't come back to the office, I wouldn't be permitted to work at all and would be forced to use PTO. I reported this retaliation to the COO by email the next day. She still refused to take my report seriously, which was another missed opportunity for Maine Health to change course. She told me to sit down and have a meeting with my manager's manager, which I did. By now, it was clear that since there had been no actual planned return to office mandate, and being back in office wasn't about training, and I was the only one being forced to use PTO, it was clear that she was trying to manufacture an attendance issue to get me fired. The stress caused by the discrimination, retaliation, and hostile work environment increased my already existing anxiety and panic disorder, which then also caused me to go into several diverticulitis flares during this time, to such a degree that I became fecally incontinent. I was afraid to leave my house because I never had any warning of when it would happen. I was seeing my therapist at least once a week and my PCP at least once a month. I had to get FMLA for the diverticulitis, which the doctor not only related to the anxiety, but said it was caused by my increased anxiety. My mental health had gotten so bad, I was having suicidal ideations. The following week, we were asked to come into the office again, which I did. However, one morning on the way from the parking garage to the office, my diverticulitis reared its ugly head and I started to have an accident on the way into the office. I went straight to the bathroom to assess and clean up. I went into the office and emailed my manager and her manager what happened, and said that if my symptoms persisted, I would need to work from home so I could use my own bathroom. I was again denied permission to work remotely and forced to use PTO. Further proof of discrimination and retaliation and the attempt to manufacture the attendance issue, because after all, just the week before, my male coworker was sick and was permitted to work from home remotely, was not forced to use PTO. I then reached out to the HR rep, who also refused to take my report seriously, but she played the game and did a quote unquote investigation where, to the surprise of no one, she found no wrongdoing by Maine Health. Something interesting happened here though, because even though Maine Health refused to actually take accountability, they returned the PTO that I had been forced to use through my manager's retaliation. If there was no wrongdoing, why would they return the PTO? It was around this time that the department decided to implement a return to office twice a week, and I wouldn't be permitted to work at all on those in-office days because by this time, my healthcare providers had determined that this work environment was so unsafe for me that they wrote my ADA accommodation request to Maine Health to continue working remotely as I had been, which was another missed opportunity for them to do the right thing. Instead, they allowed the same managers who'd been retaliating against me for reporting their behavior to be the one to approve or deny my ADA request. And again, of course, she further retaliated and denied the request. She was determined to get rid of me one way or the other. And the official reason for the denial has never been clear to me. The reason I was given was, quote, because the manager could no longer do the printing and mailings from home. It had to be done in office. But this doesn't hold water because when I got hired there, my male coworker was already working fully remote. And I was training in the office for 5 weeks. During those 5 weeks, while in office, I would do the printing and stuffing envelopes while my male coworker would take the calls from home. So we had already proved that one person could be in office doing those duties while the remote person managed the phone for 20 minutes or so that it took to step away and print and mail. So it was clear that the manager didn't want to inconvenience my male coworker that she favored so much, and it was the perfect opportunity to get rid of me. I then submitted proof to the commission showing that the mailings were not being done only in office or only by staff instead of managers. My manager told me in a Teams message, which I provided, that the mailings were being done every day and twice on Fridays, which was not an in-office day. It was still being done by the manager from home. This was when my manager got a promotion and I was forced out of my position and the department that I very much enjoyed by means of discrimination and retaliation. I've moved on from that experience in that department and still work for Maine Health, but that does not negate my experience or release Maine Health from the liability of what actually happened to me, which was caused by this. Sorry.
That was your 8 minutes. Do you want to keep going? You have 2 more minutes left.
But that does not negate my experience or release Maine Health from the liability of what actually happened to me, which was caused by the organization's blatant disregard for a serious report, which is corroborated by my healthcare providers. Thank you.
Any commissioner questions for Ms. Haley? Commissioner O'Brien.
Thank you. Good morning. I just wanted, you have 3, I believe, claims. I just want to focus on the discrimination based on sex. Aside from the fact, it sounds as though, correct me if I'm wrong, that you are, that there was a male employee who was allowed to take time off without PTO, blah, blah, blah. I'm sorry, not blah, blah, blah. But is that what you're asserting? That there was discrimination based on sex because of that one other employee?
No, I'm asserting that that's when it escalated to a beyond a reasonable doubt level, that I had provided the commission with probably 100 pages of information regarding the sex-based discrimination where she was favoring him. For instance, he was diverting work, meaning he was unavailable for phone calls, which means the phone calls all come to me. Then there were projects that we were assigned to do, or we had to make outgoing phone calls, and we would keep those on a spreadsheet. Maine Health never provided in their investigation the proof of his spreadsheets where he did actually do that work. I know he didn't do that project because
I'm sorry, can we get it to a narrow point in that? I guess my question is, was anything said, male versus female? I mean, was he is this individual the only experience that the only one that you experienced asserting that it's discrimination based on sex. I can't speak this morning, I'm sorry. Do you understand what I'm saying? Was there anything said, or why are you asserting it was because he was a male? That's why he was allowed this preferential treatment. Where's the male-female deal in here?
Because it was clear that she was uncomfortable correcting a male employee versus a female employee. When I would mimic his behavior, so he would be unavailable for phone calls, diverting the work to me. If I would mimic his behavior, then she had an issue with it. So she wouldn't correct his behavior, she would only correct my behavior.
Okay, thank you.
Any other commissioner questions for Ms. Haley? Commissioner Douglas?
Yes, good morning.
Hi.
Yeah, I was just wondering that the report says that you were reassigned to 100% remote work position as of August of 2023. Are you still in that position?
Yes.
Okay, all right, thank you.
Well,
Any other commissioner? Yeah, Commissioner David.
Isn't that the accommodation for your disability? What Commissioner Douglas just asked you? You're in 100%, you asked for 100% remote and you got it because of your disability.
But
Yes?
I was denied it from my own department based on retaliation for my report of discrimination. Does that make sense? So when I requested an ADA accommodation, the manager who was already discriminating and retaliating further retaliated by denying me to stay in the department where I was.
Well, and their position is that there was no 100% remote available in that department. Don't they have a right to say that there's an in-person requirement of 2 days a week after the pandemic?
Don't they have a requirement to prove a hardship of why they can't accommodate that request when it had already been proved that it was possible for me to continue working remotely? I started remotely, I worked remotely the whole time. When I asked to continue to work remotely, she denied it because I reported her discrimination.
Okay, thank you.
Any other commissioner questions for Ms. Haley? Seeing none, thank you, Ms. Haley. You'll have about 1 minute and 48 seconds left. Attorney Walker? Okay. Okay. Ms. Haley, would you mind muting yourself just while as we don't get feedback? Thank you. Okay. We have minutes. Great. Whenever you're ready, go ahead.
Thank you. Good morning, commissioners. And I will put on the record that there is no relation that I'm aware of with Commissioner Walker. It's a really common last name. My name is Tara Walker. I'm here on behalf of Maine Health in this matter. And I just wanted to clarify some of complainants' claims at the outset. I think it would help us to go through each sequentially so we all know what we're talking about here. Clearly, complainant has experienced certain medical and requested accommodations based on medical and mental health conditions. Those have been accommodated. She continues to work at Maine Health. So far, I spoke to the Human Resources Department last week in preparation for this meeting, and we have received no reports of any issues in that current position. She continues to work there successfully. So we're happy about that. Before filing this case, complainant had a separate case regarding the mandatory vaccination requirement that was part of Maine law for healthcare providers. That case was ultimately dismissed. Initially, there were some allegations that this case was tied to it. I think now we've sort of settled on that it's completely separate. So there are 3 challenges that she brings, really sort of centered now on this return to office mandate following the COVID-19 pandemic. In her submission of disagreement, Ms. Haley renews many of the very same allegations that she presented before the investigator that came up during the Issues and Resolutions Conference that we had with the investigator. And the investigator appropriately determined that there were no reasonable grounds in this case to say that discrimination occurred. I'll start with the sex-based discrimination claim that Commissioner O'Brien had asked about. In her charge, Ms. Haley really centers on a male colleague. And my understanding of this allegation is essentially one of differential treatment, that he was performing more poorly, I would say, and was not receiving what in her view would be the appropriate consequences. I don't think the allegation is that she was given consequences when he wasn't. Really just something that she didn't think was appropriate. I will say on background that part of the issue in this case is that complainant did sometimes interject herself to course correct her male colleague and was repeatedly instructed by her managers. That's not her role. You got to allow the managers to do that. Which I think ultimately she did. So there's the performance piece, the investigation that she referenced, Ms. Haley referenced regarding this complaint on his performance revealed that this male colleague was on a final written warning status and did also have a performance improvement plan. The managers had not shared that with her because that was confidential personnel information for that male colleague. And so I think that is in part why we are here. The second piece is around the attendance, that he was permitted to work remotely and during times when she was either asked to come into the office or if unable to come into the office to take PTO. There was one occasion really right around the time that these complaints were being voiced to Maine Health and around the time of her charge, where he had an active COVID-19 infection. This male colleague, and so pursuant to the CDC recommendations at the time, he was instructed to stay home for the full period of time until he could be cleared to come return to work in person. He still has an in-person requirement. Everyone in that department has an in-person 2-day per week requirement in the behavioral health care program. So turning then to the disability discrimination claim, complainant contends that essentially that Maine Health has failed to accommodate her and has not been able to show undue hardship in accommodating her in the behavioral health care program by providing a remote work accommodation. I think that Maine Health has provided ample proof of that, not least of which is in the job description. It's just that complainant doesn't agree with it. Like all offices, I think, probably not the commission included. Everyone took on different tasks than their normal job when it came to the pandemic. We had to sort of make do for a couple of years. That does not change the essential functions of the position. And I want to kind of turn to one of the specific functions about this role in the behavioral health care program. There are mail-in surveys that get sent out to patients and providers that are key to the federal funding that program receives at the hospital that need to be opened in person, manually input, and the managers had taken that duty on during the pandemic, even though that's not technically their duty. And as a result, when they reestablished that return to office plan, that was also a key part. During the IRC, Jackie Pearl, who's the sorry, I did that again. The human resources generalist had spoken about also supply inventory was one of the functions of a customer service representative that needed to be completed in person. And then, of course, there was training on the new software program. The managers were in the process of writing policies and protocols for that new software program. Everyone was sort of learning on the fly. And that was one of the key reasons at that time that they had moved to each, at Maine Health, by the way, each department determined their own return to office requirements. The last is retaliation. And here, there are essentially two that I can glean from the charge of discrimination. Both are MHRA retaliation. The first is that the chief operating officer copied the manager. So essentially she received a complaint of the supervisor and then copied that manager saying, hey, I received this complaint. I'd like you to look into it, or I'd like you to follow up with complainant on this matter. Complainant saw that as essentially, outing or inappropriately copying the manager. Certainly wasn't the chief operating officer's intent. It was to direct that manager to follow up and address complainant's concerns. The second was what was investigated around taking PTO for a specific medical appointment. We would dispute complainant's recitation of the facts here. She did request a medical appointment that was approved. There's no dispute about that. The manager instructed her to return to work for that day after the appointment had concluded. And that's where in the human resources investigation, which was provided with our position statement, it was determined that she was instructed to either take PTO or to return to work, but that there was a misunderstanding between the manager and complainant about the nature of the need for leave. At that time, Maine Health was accommodating her remote work request by providing FMLA and short-term disability benefits, and so they transitioned to that for the duration after the appointment that day. I will just say that she continues to work, a complainant continues to work now in her reassigned position. And thank you. Happy to answer any questions.
Commissioner questions for Attorney Walker? Seeing none, you'll have 2 minutes when we come back to you. Ms. Haley, you have 1 minute and 48 seconds if you'd like to respond.
Well, this was never about consequences for my male coworker. In fact, it wasn't even really about his behavior. It was about my manager's behavior. And they did share the information about his performance issue or his PIP that was shared with me. And it doesn't matter why he was sick or why he was out. The point is that he was able to use PTO and work from, or he was able to work from home and not be forced to use PTO during whatever illness it was. And if there was no issue, or they're refuting the initial appointment where she said I had to come back after the appointment, why did they give me back the PTO? They gave me back that PTO and the other PTO from the following week with my diverticulitis flare. They gave me all of that PTO back. Why would they do that if there was no wrongdoing, if there was no retaliation? Thank you.
Commissioner questions for Ms. Haley? Okay, seeing none, thank you, Ms. Haley. Attorney Walker, you have 2 minutes if there's anything else you'd like to say.
I don't have anything to add unless there are other questions.
Yeah, do you know the answer to that question about wanting help put that time back in the PTO bank?
Yeah,
It's in the record.
If it's
my understanding is that it was FMLA time, that part of the temporary accommodation, because complainant had requested an ongoing remote work accommodation that would have been 2 days in perpetuity. The restrictions were permanent. What they were doing temporarily while they determined whether this was something that they could accommodate or what a reasonable accommodation would include, they would provide FMLA time.
okay,
That's
so
PTO FMLA.
okay, perfect, thank you.
Commissioner Douglas.
Good morning.
Right.
Yeah. You had mentioned some things that needed to be done sort of in office, I think, in your initial presentation in terms of why she couldn't work 100% remotely. And I just want to make sure I understand what those are. There was something about things in the mail that need to be dealt with directly. Can you just briefly recap that for me?
Yeah, of course. So the mailings refer not just to everyday office mailings, but to specific surveys that get sent out to patients, providers as well, I think, but they are key to a program that provides federal funding for that department. So those surveys need to be sent out. They need to be returned, opened, and input into the database. And that's something that you have to do in person.
And then I think you said something about inventory, and I didn't catch all the details.
Yeah, that was something that was brought up in the Issues and Resolutions Conference by the Human Resources Coordinator at the time, that there were supply, in-office supply inventory that customer service representatives, which is complainant.
That was part of her job, sort of make sure that the office had what it needed. Was there anything else?
There was the new software system. So in particular, where this, when this request for accommodation took place, that particular program, the behavioral healthcare program, had completely overhauled its software. It was actually a pretty big deal for this department because they were all getting used to it. They all had to change the way that they had been processing patient inquiries and how that was being collected in the database. The managers at that time were creating policies, protocols, standard procedures for use of this software. And so they had wanted everyone to sort of experience and share in real time the issues that they were seeing show up when they encountered a problem with the new software, or the protocols that everyone started to use so that everybody could be on the same page. When working remotely, there's just not enough communication to be able to do that effectively.
Just one final question. It seems from the report that the impression is that complainant is a good employee who's never really had any performance issues. Is that, I mean, other than sort of these claims, right? Is that accurate from your perspective?
I think so. I'm a little hesitant to weigh in on that because that wasn't particularly relevant to this case, that she's not being cited for performance issues. That's not, she wasn't disciplined in this case. So it may be, there may be issues I'm unaware of, but I think that is my general impression.
In terms of drawing a contrast between herself and this other employee, I was just curious.
Yes, no warnings, no tips related to performance to compare herself to the male colleague. That's correct.
Sanders?
Yeah, I'm curious about setting aside for a moment the in-person training requirements associated with the transition of the software. You cited the inventory as an essential function of her job. You also cited collating mailing surveys out. That was an essential function as well. I'm just trying to get a sense for, when you say essential function, do you have a sense for what percentage of time as compared to the total work week would those job duties have occupied, right, that only could be done in person?
I don't have a percentage of time on the survey mailings. I'm not sure if it was 30 or 50%. I would be speculating.
Okay,
yeah.
But otherwise, MidHealth's position is that reassigning those in-person duties would have constituted an undue burden, correct?
Exactly. Yeah, our position is, this was part of her job description, or any CSR's, customer service representative's job description at the time, and assigning that to another employee, which only really would have been the managers, would have, is not a reasonable comment.
So was it only the complainant and this other person in that same job title? There were only two in that department?
I believe so.
Any other commissioner questions for Attorney Walker? Amen. Thank you very much. Next, we will hear from Jane O'Reilly, who will be presenting for Angela out today.
Good morning, commissioners. So unlike my previous case where I came in before the report writing, Angela conducted this investigation, wrote this report, but I have reviewed the entire file and am presenting on her behalf. I don't really have anything to add based on the presentations, but I'm happy to answer.
Commissioner questions for Jane? Okay, saying none, Anthony. From the parties and the investigator, at this time we're looking for a motion. There are 3 proposed things.
I move to adopt the investigator's recommendations as written in the report.
Okay, thank you. Just for the record, can you just say what those findings are?
1, there are no reasonable grounds to believe that MidHealth discriminated against Carrie Haley on the basis of sex and or religion. 2, there are no reasonable grounds to believe that MidHealth discriminated against Carrie Haley on the basis of disability. 3, there are no reasonable grounds to believe that Maine Health retaliated against Carrie Haley for engaging in MHRA and or WPA protected activity. And finally, the complaint should be dismissed in accordance with 5 MRS 4612 subsection 2.
Thank you. All right, it's been moved and seconded. Is there any discussion? Seeing none. The motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Okay. The findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results of the hearing.
Next case is Catherine Fraser versus Acadia Hospital, E23 0150. It's a recommendation for no reasonable grounds. We'll hear from complainant.
Fraser. You can turn on your video and unmute yourself.
Okay.
Can you turn on your video? Oh, great. Okay.
Hi, I'm Kathleen Fraser.
You have 10 minutes. Do you want to save any of that time?
Sure, 2 minutes.
Okay, whenever you're ready, go ahead.
My case started back in, well, what began my case, my complaint is back in 2022. I was active in union organization for nurses union. It was at that time that senior leadership met with nurses and explained to them that nursing unions aren't good for young nurses, and that I have that from multiple reliable sources that was stated to them in private. So it again got me thinking, like, young nurses, okay. And then before you know it, young nurses are being promoted upward to charge nurse managers, supervisors. So it got me thinking about, the age discrimination, which is what my claim was. February 2023, I started applying for different positions, was turned down. February 2023, I applied for one. The interview went well. I thought, I have a good chance. In March, the beginning of March, I got an email saying that I wasn't chosen for the position. I didn't get it, so sorry, I'm really really nervous. So anyways, February, I was told I didn't get the position. I filed the complaint with Human Rights Commission. In May, beginning of May, I was approached by our chief nursing officer saying that he had a position for me, that he held it open for 3 months. Now, again, I was declined for the position beginning of March, and he said he held the position for me for 3 months, which was not the case. And that's my argument for the last report that I got. Also, that report also said that they hired younger people into some of those positions I had applied for and were denied for. However, the next person under me was 40-something years old. That's still 20 years younger than me. I believe there is age discrimination occurring there. However, others people feel differently. Sorry. That's all I have to say.
Okay. Any commissioner questions for Ms. Fraser? Commissioner Douglas.
Yes, good morning.
Good morning.
So I'm just looking at the report here, and particularly this position you applied for, well, the merging of the departments, right? Where the hospital appoints a younger nurse instead of you as the charge nurse, right?
Yeah.
That's part of your claim, right? That you should have been made the charge nurse.
Yes, or even discussed it with me. There was no discussion. There was no job postings. There was nothing. It was, that actually that nurse was boasting about how the chief nursing officer approached her about the position. And then that same person later became nurse manager.
So then after the departments merged, you did work a substantial number of hours as a charge nurse, right? I mean, the report says something about 262 hours you worked as a charge nurse after the departments merged. Is that true from your perspective?
That may be in maybe a 2-year period, but not, I don't recall it being that often because we had the charge nurse.
Okay, well, I'll tell you, the report says between October 1st, 2022 and June 10, 2023.
I'd have to look at the records.
Okay, but so it's possible. You're just not sure as you sit here right now.
Correct.
Okay, and then the report also says that, part of the issue here is a union versus non-union issue, right? I mean, it sounds like it's sort of all folded in, right? Like there's a statement about the, management preferring, or, union membership is not good for young nurses, something along these lines.
Right.
New people are coming on, the management's meeting with them and basically saying anti-union things.
Yes.
I just wanted to I wanted to give you an opportunity to respond to the impression here that it was sort of union issues and not age issues that accounted for your failure to be hired for these other positions.
No, it was when they said young nurses that a light bulb went off in my head, and then subsequent, aside from the union, it's just the union was when the young nurse issue was brought up, and then it just continued. It continues till today.
Right, but I think that the import is that the young nurses are not yet in the union, right? They have not been. I mean, it falls under the sort of suasion of the union folks.
No, to be honest, they scared people so much that we did not go through with the vote. So we are not unionized.
All right, that's helpful. Thank you.
Sure.
Any other commissioner questions for Ms. Fraser?
Actually, one follow-up question, I'm sorry, because the report says something about union organizing, even though your efforts were unsuccessful. Were you involved in that union organizing?
Yes.
Steps to form a union, right?
Correct.
Okay. All right. And was that known to everyone?
I didn't keep it a secret. I'm pretty sure because I made public statements.
Doesn't sound like you did. Okay. Thank you very much.
Sure.
Any other questions for Ms. Fraser? Okay, seeing none, I'll ask you to mute yourself for now. You'll have about 5 minutes and 17 seconds when we come back to you. Attorney Randlett, you have 10 minutes.
Good morning. Can I reserve 2 minutes, please?
Yep, whenever you're ready, go ahead.
Thank you. Good morning, commissioners. Megan Randlett, and I represent the respondent, Northern Light Acadia Hospital, in this matter. I just want to start at the outset, this is the point that the commissioner was just getting at, the separation of the union versus the age discrimination issues. Those, and they're difficult to parse apart. I understand that, but I think it's really important that we try to focus on keeping those issues separate, because number one, as the investigator correctly pointed out in the report, the union issues, those wouldn't be protected under the Maine Human Rights Commission's framework. That would be obviously the National Labor Relations Board. That would have jurisdiction over that. And secondly, most importantly from my perspective, that's not part of the record here. Acadia didn't present any evidence on those points. And there certainly was no testimony regarding the last point, which complainant made, which was that she evidently was outspoken as part of the union organizing efforts. That's not part of the record, and there was no testimony on that. So going back, and I'm happy to answer questions on those issues later. I'm certain there will be some. But as outlined in the investigator's report, and as required by the applicable burden shifting analysis, which was correctly pointed out and stated by the commissioner, by the investigator in the report, respondent has presented legitimate non-discriminatory reasons for the hiring decisions which complainant has taken issue with in the context of this case. The burden shifting framework applicable to the age discrimination cases and the claims alleged by complainant require that once the respondent presents that legitimate non-discriminatory basis, the burden shifts back to the complainant to provide evidence that suggests that the reasons were pretextual. I would suggest that the complainant has not met that burden here. The record reflects that the complainant was previously removed from a leadership role in a different department, albeit a couple years in the past, based on performance concerns. And the record shows that complainant did have discipline on record, relatively recent discipline on record, minor for safety violations, documentation concerns, and attendance issues. Despite this, the record reflects that complainant was considered for the jobs for which she applied, but ultimately she was not selected for the two of them, as she was not the most qualified. She's correct that the two individuals that were selected for two of the roles were in their 40s. But as my submission, I believe it was one of the last submissions in June of this year. The candidates that were selected for those roles did have additional education and or experience that made them the most qualified for those roles. She was in fact offered a third role, which, as she just talked about, she takes issue with the job offer that she was provided, which was in fact a promotion. It was to the role of RN registered nurse 3. And she doesn't deny that she was ultimately offered this job. She just, as she's explained, doesn't feel that it was a true offer. From Acadia's perspective, it was absolutely an offer of employment. They had held the role open for a period of time. The reason from their perspective that it was held open and it took some time was because, and this is in the record, the complainant did have some restrictions which prevented her from performing hands-on restrictions of patients due to a previous injury, and Acadia was trying to determine whether or not they could accommodate that restriction in this new role. The charge nurse, the complainant has worked as a charge nurse and continues to still work as a charge nurse, is my understanding. This is a role for which, despite the fact that she actually she works a different shift than most of the nurses in the unit in which she works, because she's been allowed to continue her preferred schedule of, I believe it's 6 a.m. to 3:30 p.m. Rather than the standard schedule, which is different than that. She still has been permitted to work as a charge nurse when the schedule allows for it. In regard to the nurse manager role, the record reflects that the interim was appointed based on the fact that she was currently working in that role and was performing many of the core functions of that role while the current nurse manager was on a leave of absence. And so when complainant later transferred into that same department, the interim nurse manager was already in that role. And the record reflects that the nurse manager was qualified for the position and that she was performing the job well. And the chief nursing officer at Acadia credibly testified at the Issues and Resolutions Conference to this basis for the selection. And there's been no evidence presented that this selection was pretextual. Respondent has taken no discriminatory actions against complainant. She still continues to work for respondent Acadia Hospital today. And she has been considered for positions without regard to her age. I'm happy to answer any questions, but respectfully request that the commissioners uphold the investigator's recommended finding of no reasonable grounds. Yes, Commissioner, I see questions.
Commissioner Sanders.
Thank you. Good morning. Attorney Redley, you noted earlier in your presentation that the complainant several years ago had been removed from a leadership role in a prior role that she had, and then separately too, at the time, times relevant to the job decisions that were being made here, she also had some minor disciplinary action reflected in the personnel file. Did those two considerations also play into why she was not selected for vacancies as well?
That's a good question. I would say yes, they were absolutely considered. The applications for individuals that were internal applicants, as is the norm, their current performance in their roles at Acadia are considered as part of the application package, if you will, when they're applying for employment in those roles. So when I speak to the jobs for which she was not selected for, it would have been, when I say the others were more qualified, that is part of what was part of the determination, that others were more qualified.
Okay. And do you know when the complainant was informed that she was not the successful candidate for those roles? Did anybody give her that feedback, right? That listen, here's sort of a very specific set of or pieces of feedback about why you were not selected?
I can't speak to that. I can say that I believe it would have been others more qualified was the justification for her not being selected, but whether or not it went beyond that in further detail as to the specific reasons why she was not qualified as the other applicants, I can't speak to that.
Okay. It just strikes me that to the extent that, perhaps Northern Light and its management team did not give her that specific feedback.
Mm-hmm.
I wonder, and you can speak to this as well, in the absence of narrative, right? The complainant could have drawn the conclusion that, there must be something else happening here and insert, right, age discrimination. So I'm just curious about that piece, to the extent that there wasn't explicit feedback given to her about why she wasn't the most qualified candidate.
I think that is, I completely understand if that is the inference that was drawn. I think the response to that on Acadia's part is that the evidence that we've provided shows that there wasn't a discriminatory basis for the decision, but I could certainly understand why that would be somebody's suspicion, perhaps.
Thank you very much. Appreciate your time. Any other commissioner questions for Attorney Randler? Commissioner Douglas?
Yes.
And then Commissioner David, I see you.
Good morning. I just wanted to make sure I heard you correctly. I thought you said, in addition to this position that's in the record, I'm not seeing it now, RN 3 adult medication management position. In addition to that, I thought I heard you say that she'd been offered other positions.
Oh, no, I'm sorry if you misheard that. So the position which she was offered was the RN3 position for which she applied.
That's the one.
Correct.
This is why I asked, right? Thank you.
You're welcome.
Commissioner David.
Yes, good morning, Attorney Randlett. You just said rather clearly that there was nothing in the record about union political activity or discrimination about the union, but the investigator finds that throughout the investigation, complainant stated the reason she believed there was age discrimination was because the respondent preferred non-union activity. And so the record is replete with that issue. Would it not be unlawful age discrimination if it were proven that the respondents skewed against or for younger people because of their position on the union? I hear that we're okay. That's one question.
Okay.
Wouldn't
okay.
wouldn't
Well,
that
I
be
mean-
illegal?
So parsing that apart a little bit, like I suggested at the beginning, I think it's important to try to keep the issue separate, although I understand how they overlap.
Well, I understand why you want to keep them separate, but if the proof is
Well,
that they're not separate, then that would be illegal, would it not?
If correct, if Acadia Hospital was making decisions on a basis which was directly tied to age, that would be discriminatory. However, there's no evidence that Acadia was making any decisions here in this case based on the fact that the complainant was or was not engaged potentially in union organizing activity. And what I said, there's no evidence in the record. Acadia Hospital has presented the justification for why they made the employment decisions that they have made, which have nothing to do with the fact that the complainant may or may not have been engaged in union organizing activity. I'm not trying to be obtuse, I promise. Sorry.
Yeah, no, okay, and you referred to the fact that it would be an issue for the Labor Relations Board to say that they were doing that, and I'm just not clear about where that issue
Well, I
is
think
properly. I understand that union membership is not a protected class.
Right.
The investigator says union membership is not a protected class, but there is no union. She's not in the union, and she's not saying that she was discriminated against before that. She's saying that there's age discrimination going on, and you're saying, well, it didn't affect her because she's not getting the positions based on qualifications and stuff like that. Can't we recognize age discrimination if we think we see it?
If we think we see it. However, there's no evidence to suggest that for example, that the individuals that were selected for the roles for which she was not ultimately selected were or were not engaged in union organizing activity. I don't know the answer to that.
I hear you. I hear you. I think it's a close call, but I think you're probably right.
Any other commissioner questions for Attorney Randland? Seeing none, you'll have about 3 minutes and 39 seconds when we come back to you. Ms. Fraser, I apologize. I gave you the wrong number. You have 7 minutes and 17 seconds to start. Left to you, sorry. I forgot that you had requested an 8 minutes instead of 10 at the beginning. So whenever you're ready, go ahead. Oh,
You're on mute.
Attorney Randlett's explanation that other qualified people were chosen for those positions is not accurate. I know the folks that were accepted into at least one of the positions, and she worked in substance abuse with adults. Just prior to that, she worked in the education department with staff who are adults. As far as the recent write-ups against me, one for attendance was because I was ill. We have posters all over the building saying, if you're ill, do not come into work. So I would call and say, am I ill? And they'd tell me, well, do a COVID test before you come in. You're allowed 3 absences in a 90-day period, and that's what that's from. As far as being let go from a position in the past, I actually filed a complaint with Human Rights back in 2017 when I was being harassed by my supervisor.
If that's in the record, Ms. Fraser.
I'm sorry?
I'm not sure that complaint is in the record.
Actually it is. I complained, yes.
Investigator Brindley.
Response to that.
I'm sorry.
That the Acadia is trying to discredit me.
Hang on a second, Ms. Fraser. I'm going to pause your time. I'm just asking the investigator, is there a reference in this complaint to a prior MHRC complaint?
No.
Okay, so we're not going to talk about that complaint.
Oh, okay, right. No, I'm just, yes.
Okay.
But I was not let go from, I chose to leave that position because I was being harassed. That part was, I put in my report. So some of the information is inaccurate. And as far as being given time for that the position, the last position that I applied for, I was denied in March, and in May, early May, I was told that the position was held for me for 3 months. March, April, May, that's not even 3 months. So it was not. And it wasn't until I filed the complaint that I was approached with that position, the offer of that position. Again, even though I was already declined for that position, because I guess the team didn't think I was the right person for the job. But when the director of nurses approaches me, I'm okay for the job. That's all I have.
Any other commissioner questions for Ms. Fraser?
Yes.
Commissioner-
Yes, is the job that you finally did take was nurse 3. That's a higher level than nurse 2. I mean,
Yes.
sometimes these things, 3 is lower than 2, but so that's
Yeah,
a promotion or increased salary.
Correct.
Okay, thank you.
Any other questions for Ms. Fraser? Seeing none, thank you very much, Ms. Fraser. Attorney Randlett, you have 3 minutes and 39 seconds if there's anything else you'd like to add.
I don't have anything else to add, but happy to answer any follow-up questions.
Commissioner questions for Attorney Randlett? Seeing none, we've heard from the parties. At this point, we'll hear from Alex Brindley, the investigator assigned to this case.
Good morning, everyone. Alex Brindley here. So I want to take a step back from the union issues. To be entirely honest, they're not really important for the analysis. We can do it without it. So for the first 2 positions, the charge nurse and the interim nurse managers, they were appointed by management and are therefore, we can't do the prima facie case on it in the first place because you need to apply for it. She could not apply for it. In the final 3, complainant was offered 1 position. She declined. The other 2 positions, respondent determined that they had, more qualified individuals. They provided me their resumes, their backgrounds, and I agreed that, it was a rational decision to make. The only reason I added the union basis is because I thought it showed complainants, it was just her response to respondents' legitimate non-discriminatory business reason for appointing these other younger individuals to the job. She believed that, the respondent did not like union busting, which she believed had age biases. There is no evidence to support that. It was just her belief. And, like I stated in my report, union membership is not protected under the Maine Human Rights Act. So it seems to me that, complainant can make her prima facie case for the last 3 positions. She applied and was not chosen because a younger individual was, chosen instead of her. Respondent responded, providing their legitimate non-discriminatory reason, showing that the other people chosen for the positions were more qualified than complainant, which I agreed with. The last position, complainant was offered the position, but she chose not to take it. And complainant couldn't really provide any information to rebut that position. I'm open to any questions.
Questions? Yeah, Commissioner David.
Alex, it's not quite true that there's no evidence about the union in the record. You say that there's evidence that her testimony is that they were telling younger nurses that unions aren't good for young nurses. I think I'm coming down to the fact that in this case, I'm not convinced that that on this evidence that it's pretextual that those other promotions are made. But I want to thank the complainant for bringing up the issue. I don't think she's been successful, and I don't think you should apologize for putting it in. I think it really is. It is part of the case. I think it would be unlawful discrimination if there was substantial evidence that they were skewing towards younger without promotions being based on demonstrable criteria that justified them. And I'm attuned to looking for that, but I guess I'm not seeing it in this case, but we're going to get that case.
So I think what happened here is, complainant had the belief that respondent did not like, union members, and they were trying to
Yeah.
the younger employees that they did not want to join the union for XYZ reason. And then there's this very tenuous thread that complainant is creating that she's believing that in fact, had some impact on the respondents
Right.
choosing younger employees. I just think that thread is a little too tenuous there. And the respondent did show that, the people that were chosen for the positions were in fact qualified for the position.
Yep, I hear you, but the thread is there.
Any other commissioner questions for Investigator Brindley?
Thank you.
Thank you, Alex. We've heard from the parties and the investigator. At this time, we're looking for a motion. There is one proposed finding.
Yeah, so I move that we adopt a recommendation of the court finding there are no reasonable grounds to believe Acadia Hospital, DBA Northern Light discriminated against Ms. Frazier on the basis of age, and the complaint should be dismissed in accordance with 5 MRS 4612, Section 2.
I'll second.
It's been moved and seconded. Any discussion? Seeing none, motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Commissioner Samples.
Yes.
Findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results of the hearing. Ed, could we take a 5-minute break, please?
Sure. 5 minutes. Ready when you are. All set, Kip?
All right.
Okay. Next case is E23-0182 Ursula Scott versus Green Pages Technology. It is a recommendation on one count for a finding of no reasonable grounds to believe discrimination existed, and therefore we will hear from the complainant, Ursula Scott.
Commissioner David, commission members, thank you for your time. My name, as you've heard, is Dr. Ursula Yvette Scott. While I was not advised to amend my complaint to reflect the rebranding of Green Pages to Blue Mantis, I did use both names in my response and will do so here, as Green Pages was the name at the time of my employment. It was the name at the time of my termination, and when they submitted their documents, they also provided everything under Green Pages, including the logo. I do disagree with the investigator's report. I will highlight relevant factual errors in the report that I outlined in my written response and additional relevant facts at this time. The investigator's interpretation of the law was limited to her approach to the case. There was no discussion of the legal interpretation of the Crown Act, only the expectation that a violation must be repeated in order to be egregious. Little can be repeated when employment is terminated almost immediately after each previously outlined act of blatant aggression or varied microaggressions. According to the Maine Legislature Revised Statutes 4612 Procedure on Complaints, the commission or its delegate, commissioner, or investigator shall conduct such a preliminary investigation as it determines necessary to determine whether there are reasonable grounds to believe that unlawful discrimination has occurred. This section further states the commission must have access to, and in this case it's Blue Mantis's premises, records, documents, individuals, and other evidence or possible sources of evidence. This includes interrogatories. Interrogatories were served on the respondent. The respondent provided answers to only select questions. So two issues arise. Number one, respondent was not forthcoming in their responses to several items. Number 2, respondent must be held accountable for refusing to supply the investigator with records, documents, or possible sources of evidence for the investigator's examination. Respondent simply redirected the investigation by telling the commissioner's investigator what was relevant in this case. See Section 2, Part 4, Summary of Investigation. The word failure is used in 2A, Point B, administrative dismissal. In the investigative summary, respondent stated, "I was discharged based on performance." That claim has been thoroughly disproven. I do not agree that my claim ultimately fails on other grounds, such as jurisdiction. When a company employs staff in various remote locations, it's incumbent upon the claimant to identify who has authority to rule in the matter. Hence the reason for providing evidence of the respondent's business location and the actual home base being in the state of Maine. The reason the company disputes this is questionable. My experience is described as a hostile environment and what I believe to be a race-based comment. In a work environment where I've gone from straight hair and no inappropriate comments to having my natural hair questioned in a formal, seemingly professional setting is disturbing and a violation of my rights under the Crown Act. Case law and Maine's own definition of the law deems the supervisor at the time's behavior race-based. I stated that reports were coming to me about her attempts to disparage me. Those individuals were not interviewed. This would have proven and provided the investigator with more than just a one-time incident. The final and most damning form of discrimination is termination. The reason given by respondent has been proven false. Therefore, all false statements must be treated as such. In Part 3 analysis, the chances of prevailing in a civil action is strengthened by a thorough review of the facts as presented in interviews of named individuals. It was complainant's expectation that the Blue Manta separation agreement would have been among the documents requested by the investigator. That alone, the separation agreement, is a violation of Maine law, HP 711. Part B, legal analysis. My first replacement lasted less than 3 months. My second replacement resigned after 4 days. See Respondents Exhibit C. An interview of the Caucasian male or the consultant would have illuminated critical information about one person's ability to perform the job duties. Documents I provided proved by my ability to excel in this role. If respondent lies about hiring not one, but 2 people to attempt to fill the role, what is the reason, if not race? In the case law provided, Santiago Ramos versus Centennial PR Wireless Corp., respondent was tasked with providing specific performance missteps on behalf of Ramos. There were also witness depositions in that case. Investigator explained, and I quote, "Once complainant has established prima facie case, the respondent must, to avoid liability, articulate a legitimate non-discriminatory reason for the adverse job action. Respondent's proffered reasons should be rejected." Recruiting work is mentioned, and I've provided substantial information that disproves that I was unable to do the job. But in addition to recruiting, I was also required to train, develop, and apply my knowledge of adult learning theory. Nothing was provided to the commission by respondent that reveals any records from VP of HR. Such documentation is mandatory practice for employers' HR department. Statements from respondent are presented here as fact without the benefit of evidence. Finally, the EEOC provides enforcement guidance concerning vicarious liability for unlawful harassment by supervisors. Stating causation is established if the evidence shows that the complainant was subjected to harassment, and this has been proven. According to the EEOC, employers are automatically liable for harassment by a supervisor that results in a negative employment action such as termination. The Superior Court cases Farragher versus City of Boca Raton and Burlington Industries versus Eller established that employees are liable for their supervisor's harassment if it results in a tangible employment action. Therefore, while the initial staff of Green Pages Blue Mantis hired me on the basis of my skill set and expertise, the individual they hired thereafter, who then became my supervisor, behaved in a manner that places the employer in a position of vicarious liability. It only takes one person and a short amount of time to alter a person's present and future, and it was swift, 7 days to be exact. The new VP was my supervisor for 7 days. Nothing that Blue Mantis or its representative has said has proven the company to be upstanding or honest in much of its reporting or responses to this claim. Since they failed at proving my termination was due to an inability to do my job, and all others who were hired to perform the same or similar duties as mine after my termination were Caucasian, and the company has sworn that no one was hired after my termination, it stands to reason that this adverse employment action was race-based. They made the decision of employing a VP who did not approve of a minority hire. Therefore, this case should be decided in my favor. Thank you.
Thank you, Dr. Scott. Are there any commissioner questions for the complainant? Commissioner O'Brien.
Thank you. Good morning. I think it's still morning. Yeah. You just said something that I didn't see in here, and one of your last sentences was that the VP, I think you said,
Yes.
did not approve of oh, see, I didn't write it down. What was the last thing you just said about it, the VP who hired not approve of?
Did not approve of a minority hire in such.
Yes, that's it. Can you explain that? What do you mean he did not approve?
The behavior that I received.
Yep.
And the comments that were made in meeting after meeting reflected her disapproval. Every comment that she made was disparaging regarding my culture or the company's culture or my ability to do the job.
Okay, thanks.
Commissioner Douglas.
Yes, good morning, Doctor.
Good morning.
Yeah, so you just stated in response to Commissioner O'Brien's questions that there was a culture there where all these disparaging comments are being made in meeting after meeting. What I see in the report is a comment about your hair, which I don't quite understand. I think I understand it, but anyway, it's not important. But I see something about your hair. We all know what happens sometimes in these spaces where people's hair is different and folks make inappropriate comments about the hair. You and I both understand that, right? What other comments were made?
How did you do your job where you come from? We need to make sure that we are hiring people that fit the culture. Those comments were only made in meetings where I was present. And the meetings would always begin before others would join the meeting. The only other witness was someone who, the one person I mentioned in my report that had been there for 4 years. She was the only person who witnessed this behavior. Did I answer your question?
Yes. Were there any other comments besides the ones you just mentioned?
Yes. The one about where I come from.
Okay, I apologize. Dr. Scott, the investigator is saying that these are not in the record.
Okay, so then that leads to another question.
They're in the record.
All right. We can be comfortable with the fact that, you know, you are making this allegation today that there were a number of statements that were made that you feel were inappropriate, okay?
Others were hearsay that only witnesses would have been able to confirm.
Right. Okay, well, apparently we're not going to discuss those because some of them are not in the record, is what I'm being told, and that's just Maine Human Rights Commission procedure, okay? So I just want to give you an opportunity to tell us, to the extent that it's actually in the record, aside from these statements that you're discussing today, right? The statement about the hair and so on and so forth, the fact that you are an African-American woman, what other evidence is there that you were terminated from your position because of race?
I was the only recipient of the behavior that I described in my claim.
Okay. All right, thank you.
Any other commissioner questions for Dr. Scott? Commissioner David?
Dr. Scott, as I understand it, the respondent's position was that they eliminated the position and just left it to a supervisor. Is that correct?
That is what they reported, but that was not true.
Okay, and what in the record is that what was not true about it? You were talking about hiring 2 other people, and I'm not sure that I saw that.
Yes, there are actual images of their LinkedIn profiles that match Exhibit C from the respondent. Those 2 individuals were hired after me to take that role. I even received a LinkedIn note from someone else who saw the vacancy after I was terminated. She assumed I was the person who was doing the hiring, so she accidentally sent it to me.
And this position, another thing that respondent says, or I think will say, is that how could they be discriminating against you if they hired you as an African-American woman and just a couple of months later terminate the position? What's your response to that?
My response is, this is why I focus so much on the timeline. I was employed in September. The VP of my area was not hired until after I was hired. So the entire culture of that company was inclusive. It was, we look at your skill set. All of this occurred after she was hired as the VP and then placed herself as my supervisor.
Okay, so she's hired afterwards, and it's your position that that's where the discriminatory behavior comes from.
Exactly.
Is that position? Okay, thank you.
Any further questions for Dr. Scott?
Were you all able to locate the exhibits of the 2 people who were hired after me?
Dr. Scott, the commissioners only have the investigator's report and your submission of disagreement. That's what they get in any case. So they haven't seen the exhibits, but the investigator has the file.
Okay, thank you.
So you'll have 2 minutes and 51 seconds when we come back to you. Attorney Israel, are you here for the respondent?
Yes, I'm here on Zoom.
Okay, and you have 10 minutes. Do you want to save any of your time?
I'll reserve 2 minutes, but I don't think I'll speak for 8 minutes.
Okay, whenever you're ready, go ahead.
Thank you. As the commissioners know, if the investigator felt that the investigator didn't have sufficient information to make a decision, there's an ability to make phone calls, request additional information, and issue subpoenas. The investigator clearly thought in this case that that was not necessary, and Dr. Scott is trying to blame my client for not providing information, but the information was not requested. The answers that were not completely responded to in the interrogatories were things that were not relevant to the elements of the claim. And again, had the investigator thought that the investigator needed further information about those particular topics, the investigator could have requested them and they would have been provided. Bottom line here is that Dr. Scott has alleged race-based discrimination and has the burden of proof. And the burden shifting approach was applied properly by the investigator. The employer has eliminated the position. The documents that Dr. Scott has supplied do not show that that position was filled. I'm not sure what they show, frankly, but I can tell you that that position with that title has not existed since Dr. Scott left our employment. So what this comes down to is the evidence of pretext is a number of comments about her job performance, admittedly, in a number of meetings with her supervisor, and one question about a change in hairstyle. I think the line is, what happened to your braids? And I understand that the Crown Act protects discrimination based upon hairstyle, but I don't think it makes it illegal to ask an employee about the fact that they changed their hairstyle, regardless of the race, creed, or color of the employee. And so there's no evidence to show that the job elimination was a pretext based upon or evidence to show that there was discrimination based upon race or hairstyle in this case. And I'll be happy to answer any questions.
Commissioner Sanders.
Sure. Good morning, Attorney Israel. So the timeline here is troubling, right? Position is created in September of 22. New VP is hired in October of 22. And it sounds like from the complainant's statements earlier today, she was fired 7 days later, given a reason in part that her termination from employment was due to performance issues. Is it your client's position that in 7 days' time that the VP came to the conclusion that, look, there are sufficient performance issues here to in part base this termination on poor performances? Do I understand that correctly?
Yes, this position that was created was a very high level position. It's no secret that the labor shortage has impacted every business in the country. And my client is in a high tech business, very highly impacted by the labor shortage. They needed somebody who could get in there and drive recruitment. And Ms. Scott's emphasis in her September 23 submission to the investigator that she didn't think that was the primary focus of her job. She thought the primary focus of her job was to build an internal promotion and talent retention ladder, speaks volumes to why she wasn't getting the job done. And I know that it's not in the record, the two comments that she mentioned, but those also are very illustrative of the problem. The question, how did you do your job where you came from, was intended to ask, when you worked for your last employer, how is it that you got your jobs done? Because you're not getting it done here. And the question of the statement, we need to hire people who fit in our culture, again, it was directed at her job, which was to go out and hire people who were a good fit for the organization. Dr. Scott has admitted that all of the comments that were made in the meetings that she thought were race-based were actually about her performance. And yes, it only took 7 days for the new VP of HR to figure out that this was the wrong person to get the retention or the recruitment job that needed to be done.
Thank you for that. And yet, isn't it true too, right, that there's no documentation to support the challenges with Dr. Scott's performance? Is that right?
That's true. But again, it goes to the 7-day timeline. The new VP came in, hit the ground running, met with all of the people who were reporting to her, and quickly determined that this was a position that she didn't need, that she could do a better job getting people in the door as part of her job than this full-time person was doing in this position. And unfortunately, we don't have testimony from the VP of HR. No one ever reached out to her. So, and she's no longer with the organization, so I couldn't have voluntarily brought her along.
Can I ask, did your client follow, well, first of all, does it have a progressive disciplinary policy that it relies upon in managing employee performance issues?
It does not have a formal progressive discipline policy, no. And again, this was not disciplinary. This was a position elimination. The position was created because there was an emergency on the ground. We need bodies in the door. We need to fill a bunch of vacant positions. The incumbent, Dr. Scott, had a month in the job and was not getting that need met. It was not in a week. It was determined by the VP, the new VP, that the job wasn't getting done. But it wasn't based solely on her interactions with Dr. Scott during that week. It was based on a review of what Dr. Scott had done since she'd been hired.
Thank you.
Yes, good morning.
Good morning.
I just wanted to get your interpretation of a comment in the report. And I'm reading from footnote 3. It says, and I'm just going to read the whole thing. It says specifically, the supervisor asked, quote, "Where did you put your braids?" Question mark. What did you, that's a really curious sort of way of phrasing a question. Where did you put your braids? What did you, if you have an understanding as to what was actually being asked there. What does that mean? Where did you put your braids?
I'm not sure that was the exact wording of the question. That was what Dr. Scott reported to be the wording of the question. And again, this supervisor was not interviewed and was no longer with the organization when the complaint was brought to my attention for a response. So I assumed that the question was, what happened to the braids that I saw on you in the last Zoom call? Remember, this is a fully remote employee, and your new look, whatever that might have been, was very 1920s. I mean, again, I don't know the context of that. That was what was reported by Dr. Scott, but the Crown Act is designed to protect people against discrimination because of hairstyle. And this is simply a comment that could have been made to any employee about a new hairstyle, not something that was related to a black hairstyle specifically.
Thank you.
Commissioner Sanders?
Yeah, in follow up to that, you talked about context, so let's talk about context then. You note that, right, the comment about hair came up in a very specific kind of context. I'm struggling with that incident layered in with a question about, good fit. And then, a comment about where you come from, taken together in a course of conduct. Couldn't a reasonable person interpret those series of remarks together as evidence of race-based animus?
Well, again, the two latter comments you talked about are not in the record. And, we're all only speculating because, again, we don't have the person who's allegedly made those comments here. But, how did you do your job where you come from? I don't think means the town she grew up in. I think it means the last job she held. How did you get people in the door? How did you hire new employees at the last job you held? And when we're talking about a good fit with the culture, I think Dr. Scott is insinuating that we're talking about her fit with the culture. And I think it's equally reasonable to assume that we're talking about hiring people with a good fit as part of her job. Again, we don't have the full details on those comments, and I would look to the investigator for comments on how the evidence came together.
Thank you for that. Also, too, I'm really curious about there's some sort of lack of clarity in the investigator's report and in comments here today. The job that Dr. Scott had, right, that she was terminated from, we understand that those duties were assumed by the VP at that time. Is it your client's position that the job from which Dr. Scott was terminated no longer exists?
Correct. It has not existed. It was created when they hired Dr. Scott, and it ceased to exist when Dr. Scott left.
Okay. And
Now,
all the duties that Dr. Scott was performing, are those duties, or were those duties, understanding the VP no longer works for the organization, were those duties dispersed amongst many staff, or did the VP themselves, right, assume all those duties?
at the time, the VP assumed all those duties. I would have to say anecdotally, the reason the record is so confused is that VP is no longer there. The organization hired an outside consultant to reorganize its HR department. Its HR department has since been completely reorganized. Its CEO has stepped down and he's become chair of the board of directors. The CFO, Mr. Torres, who's mentioned in the complaint, has also been replaced. No, but I'm just explaining why there's,
And if it's not in the record, we're not going to discuss it, and please don't use the names of third parties. Any further commissioner questions for Attorney Israel? Commissioner O'Brien.
Again, if it's in the record, I have never seen this, but that really doesn't mean anything. In October, the newly hired Vice President of People and Cultures, which was a supervisor. Are you able to tell us if it's in the record, like what job responsibilities? I don't need a job description, but what does that mean? I've never seen this.
The VP of People and Culture was the highest level HR position at the firm, at the organization. That person reported directly to the CEO.
Okay, but are you, again, and maybe I've been out of the real workforce for too long, but what vice president, people and culture, what really does that mean?
It's what we used to call HR.
All right, never mind, it's not in the record. Thank you.
It probably is somewhere, but I don't know.
That's what the investigator is telling me.
Okay, thank you.
Any further questions for Attorney Israel? Seeing none, we have 7 minutes and 38 seconds when we come back to you. Dr. Scott, you have 2 minutes and 51 seconds if there's anything else you'd like to add.
I have nothing further. Thank you.
Any other commissioner questions? Yeah, Commissioner Decker.
Yes. Doctor. I
Yeah.
want to basically put in front of you the same statement I put in front of Attorney Israel. This supervisor statement, where did you put your braids? I just find that to be very curiously worded. And I wonder, first of all, is it your position that that's an accurate, is that accurate in terms of what was stated? Where did you put your braids?
Those are her exact words, and she asked me twice.
Okay, what did you take that to mean? That question, if you had an opinion on what she was getting at with that curious wording.
I was, first of all, shocked, and then I just saw it as an insult to my appearance, because I had taken out one style and put on a wig. So when I was in that meeting, I was wearing a short wig.
Okay, but I'm trying to get at a very specific point.
Okay.
People that may not understand why this was so offensive. When somebody says, where did you put your braids? As an African-American woman, what did you take that to mean? Why did you think that was racist?
It insinuated that I was not wearing my own hair.
And did you find that to be offensive and racist?
That was very offensive and racist.
Thank you.
Any other commissioner questions? Yeah, Commissioner David.
Dr. Scott, I failed to ask you this the first time, but now after Attorney Israel's presentation, I want to ask about the job performance. If we are being asked to find that, but for your race, you would still have the position, don't we have to find that you were doing the job? Is it your position? Is there evidence in the record that you were doing the job? Absolutely. Against his accusation that you were not, that the job was hiring people and you didn't hire people? I mean, is it as simple as saying, who did you hire? And
yes,
go ahead, respond to that. Yeah.
Yes, it's a simple matter of looking at what's in the record, because I not only provided email correspondence, but in that it shows you, thank you, Dr. Yvette, for, that's what they call me, for finding this person. Here's a meeting where we need you to locate this person. Here's the interview I've scheduled for this person. So I was doing the recruiting work and I was sending out offer letters, and there's evidence of that in the record.
Were you finding that difficult post-pandemic?
No.
So you're not saying that they're being, well, you are saying that they're being hypocritical, or they're ignoring the evidence of your doing your job because of racial discrimination.
Correct.
Okay.
There was no difficulty with the job. I brought many years of experience to that particular role.
And that was evident when that was presented when you were hired.
Correct.
Yeah.
Any other commissioner questions? Any other commissioner questions for Dr. Scott? Seeing none, thank you very much. Attorney Israel, you have 7 minutes and 38 seconds. If there's anything.
Thank you. I just want to follow up briefly on the evidence of job performance. There's a mountain of documents that were submitted by Dr. Scott, and in there, mostly what we have is a bunch of internal emails where people are explaining their needs to Dr. Scott, or where she's doing rudimentary tasks such as asking, what are the hours and salary of this position. I didn't see very much evidence at all of her actually going out recruiting and hiring people. There's a lot of internal communication about needs and how to go about hiring people. I don't see and certainly, maybe it's just not an organized presentation, but I don't see in there evidence of bringing people in to fill positions in the month that she held the job.
Commissioner David.
But you are saying that the vice president could evaluate that lack in 7 days and discharge her.
That's what happened. She came in, she looked at what has Dr. Scott accomplished so far. She met with Dr. Scott a few times to come up with a plan to get things moving. There was no plan evidenced, and she decided to just take over herself.
All that within a week?
Apparently. It was only about 7 or 8 days.
I guess I need to ask the investigator about those meetings.
Seems like a segue. Any further questions for Attorney Israel? Seeing none, thank you very much. We've heard from the parties, and next we will hear from Jane O'Reilly, the investigator assigned to this case.
In the afternoon. Oh my gosh, it's 12:09. We're in there.
And your food is almost here.
Good afternoon, commissioners. This was my case. I investigated it. I was the only investigator on it, and I wrote the report. I'm going to talk a lot for a second, because most of what was just discussed is not in the record. In her initial presentation, she talks about a complainant talks about many comments that were made. The only comments that I double checked, I looked in the record, complainant submitted a lot of material, had plenty of opportunity to submit me more material, and the only comments that were made reported as part of the record were the comments that were made that are in my footnote. So to the extent this report is analyzing whether or not there was racial animus or a hostile environment, solely based on those two comments, I did not have any other information at the time, even though the parties had opportunity to present that information. Similarly, with regard to the jobs being filled post complainant, whether or not that job was eventually recreated or other jobs were posted, certainly there's nothing in the record that suggests the specific job title that was used for complainant's job was reposted. There are some other job titles in here like talent acquisition specialist or talent acquisition associate. She did provide information that other people were hired after her in the talent acquisition department, but not sufficient evidence that that job had been recreated or that someone else had been rehired in that position. Ultimately, it wouldn't be relevant to her claim of discrimination because she met her prima facie burden. Her job, whether they were absorbed by someone who was already there or whether they rehired someone, the person who took over the job duties was white and she was black. So that, for purposes of prima facie case, establishing that the person who took over the job duties was of a different race, that was established. Now I'm going to talk a little bit about process. So as you know, the commission gets a lot of complaints. We do an initial assessment. Not all cases are investigated to the same depth or breadth as every other case. And that's based on the face of the complaint when you get these initial pleadings, whether or not there is sufficient suggestion of animus that needs to be investigated further. In this case, despite complainant's comments today about sort of misbehavior by the respondent or the way they participated in this investigation, those two comments that were made that are in my report were the only suggestion in all of the evidence that complainant provided and all of the information that I had that anything was related to race at all. They hired her knowing her race. Yes, the person came in, the decision was made extremely quickly. Ultimately, you can make a bad HR decision. You can make an unfair HR decision. You can make a decision that appears to be, I was just hired in this job. I wasn't given a chance to show what I can do. But if there's no evidence that that decision was based on race, it's not a discriminatory decision. And that's what my investigation is focused on. There was no suggestion in any of the materials provided that race was a factor at all. And complainant has to prove that but for her race, she would have retained the position. I also would disagree actually with respondent that there's not evidence of performance issues, whether or not, again, complainant agrees that her performance was not, adequate. There is evidence in the emails that complainant herself submitted that there were disagreements between process and how the job should be performed between her and the new VP who came in, even in that short period that the vice president was there. So I found that not just respondent statements, but the actual correspondence that was provided by complainant about how she was doing her job, there was a disagreement about how that job should be performed, what the job duties were, to suggest to me that, again, there was support for respondent's decision. Ultimately, even if I had found lack of support for respondent's decision, it's still complainant's ultimate burden to prove that the decision was false, pretextual, and that but for her race, she would have retained the position. So I'm happy to answer questions about what's in the record. Again, it was a very limited investigation because that's what my assessment was when I first picked up the case. Yeah.
Just curious, is it in the record, the racial makeup of the employees in that department? Do we have any information about that?
No, we have a list of who was terminated. So we always ask initially if, based on the same adverse action as part of our initial request for every complaint, whatever the adverse action is that the complaint alleged, we say, okay, give us for the past 2 years, every employee you've discharged and for the reasons. So we have that list, a lot of Caucasian people being discharged. So we have that comparative information. I also will say, that reminds me, one more thing I wanted to say before I forget, the discussion of the comments themselves. So in case this wasn't clear, based on my footnote regarding the hostile work environment, my assessment was not that the comments weren't race-based or otherwise racist comments. It may very well be, right? I mean, I can't speak from personal experience, but I'm not going to, dispute with complainant that was felt very much and was a race-based comment about her hair. But a comment can be race-based without rising to the level of a severe and pervasive hostile environment based on a singular comment. So that was my reasoning. Not that the comment wasn't based on race or that, it's the same comment that you could, I think clearly a comment based on where your braids is not a comment without racial context. I don't think that is something that, is a comment about hairstyle. Sure, it could be based on everybody, but I think it's pretty clear that it was race-based, but whether or not it was offensive, severe, creating a severe or pervasive, severe or pervasive to establish a hostile environment. I did not. Yeah.
It's an excellent report, first of all. The business about the job being reposted, I think, I just want to make sure I understood what you said.
Mm-hmm.
Said was there were, the complainant had submitted evidence of repostings from that department,
mm-hmm.
but not necessarily for her job.
Yeah, I think
this is that exhibit C that she was referring to earlier.
Yeah,
yes.
and I actually found a couple in here. So one that definitively says like, welcome to the team, and it's talent acquisition associate, which is not what complainant's title was.
And the job duties were, to the extent they were listed, they were not similar.
So the posting does not include what the job is. She got the posting from the individual's LinkedIn page. It wouldn't have a job description. So I'm not sure what the job was, but it wasn't the same one.
Just what was her title? Complainant's title.
Talent acquisition and development partner.
Okay. And then on the job performance, right? You said that there were emails between this new supervisor and complainant about, how to do the job, right? I mean, were these, I don't want you to read them or anything,
yeah.
but I mean, were these like process related? Like we do this before we do that? Or were there comments to the effect of, or with the import of, you're not doing your job right?
The tone of the email, the one specifically that I'm remembering now, was sort of, thank you for this work. We prefer you do these steps first. You sort of jumped ahead to a different step and we want to make corrections. We're not actually going to do it this way. We're going to do it different. The other was an email from complainant back to the supervisor saying sort of, okay, we'll do it this way. That wasn't my initial understanding and it's a move away from the team approach. Please tell me if I'm doing it right now. Kind of, there are discussions going back and forth about the way that complainant's doing things. Again, I can't speak to whether or not, I don't know the specifics of the job well enough to know whether or not she was actually doing it well or not. And it was so new, maybe the respondent didn't know what they were expecting.
We've got a new supervisor in, right? And she's communicating with her employee and they're trying to get on the same page in terms of how the job should be done. Is that fair?
Yes, I think that's a fair assessment of the few emails that are in.
Thank you.
Commissioner Walker and then Commissioner David.
I have a question, and maybe more for Barbara. Footnote number 2, do we have jurisdiction? And I like your conclusion that because the claim ultimately fails, the issue of jurisdiction will be assumed, but we don't know the claim ultimately fails. So that's really a 2 or 3 part question that you can tell me to wait and go away now. Do we have a policy on jurisdiction? At least in my practice, it's like you kind of conclude that there is jurisdiction before we do any of this.
Yeah, Colin's gonna have a good laugh now because he was messaging me saying, so what do we do about the jurisdiction question if they decide this is not no reasonable grounds? And I said, don't know. Honestly, I'm the one who punted that. There was an office in Maine at one point. Potentially while complainant was working there, the dates are unclear. But there was no contact with Maine regarding this employment situation. I think we figured that out late in the flow of things. And so because the investigation had happened, we just continued and reached the decision. If Jane had been recommending reasonable grounds, I would have had to wrestle with that before we issued the decision. I don't see any clear jurisdiction. I mean, at this point though, we've had it for however long we've had it, and it's too late for complainant to file anywhere else in a timely manner. I do believe that her found here we may have, because it was dual filed. I assume it was dual filed because it's a race claim. With the EEOC, her litigation claims will be fine for court wherever she files, because she's met her she's jumped through the administrative hoops. So the answer is, I don't know, but I don't think it's going to matter to anyone except whether we would be able to file suit, and I'll cross that bridge if we come to it. Stuff like that.
I think also just for the generally a jurisdictional question is a question we decide at the outset because it's apparent. Every once in a while we get a case where it's not apparent until we've already gotten into the investigation, and at that point we generally let the investigator finish their work.
Yeah, and that's what happened here because both parties will admit there was a main office. The question is, so, if you're going to talk about shoes and contacts and stuff, respondent had some. Yes, but again, that's why I said I would need to do some unraveling before I could be very confident in my assessment of whether the commission itself would have jurisdiction later down the road.
Okay.
I can answer any facts about what's in there.
Commissioner David had a question also.
Yeah, just following up on Commissioner Douglas's last question to you about those 2 job descriptions. Just my observation is, as you read them back, they certainly sound identical to me. I mean, there's sort of, fancy verbiage there, but they sound pretty close. But the question I wanted to ask you, Jane, is in your report, when you get to the conclusion, you state that she's made a prima facie case, but that's not enough to show that the respondent's reasons were false or pretextual. And then you state as the reason, and I'm reading now, complainant was only employed for 2 months before her position was eliminated. Since respondent hired her knowing of her race, it's unlikely that they decided a few weeks later that she should be discharged due to race. Aren't you sweeping under the rug by saying they hired her and they decided? The fact, as I'm now understanding it, that she's fired because of a new hire that comes in, looks at the job or looks at her race whichever, and says in a week's time, you're gone. It's not they don't fire, the they that hire her are not the they that fire her. How do you respond to that?
She wasn't the only one who made the firing decision. The VP who came in, the VP who came in, who made the assessment of her performance, reviewed that information with another employee, another senior employee who approved of the termination, who was involved with the company when complainant was hired.
Okay, that's a significant response. Thank you.
I will also say, in conjunction with that, the statement that complainant made today, focusing on the specific individual and saying that she didn't approve of minority hire, that's not on the record.
One more question.
Yeah, well, it would be in court if there, you know, if it was as likely as not that she could persuade a jury of that.
Right, I'm just pointing it out in terms of what I based my analysis on. I didn't have that statement. There was not.
Okay. Then one more question about your analysis. Based on what you've heard today and her complaints that you didn't go far enough, do you wish that there was greater depth to the investigation, that you had demanded some other things or demanded the full answers to those interrogatories or those kinds of things?
I think we generally don't ask
like
investigators to second guess their work at this point.
Okay.
That's not in the record. Commissioner Douglas and then Commissioner Sanders.
We had talked about performance issue, or established that there was emails between this new supervisor and the complainant, right, where they're sort of trying to figure things out. My question is, was there evidence in the record of performance issues that were raised before this new supervisor came?
No, she didn't have a supervisor in the first part of it.
Nobody else had any complaints?
No, she wasn't. I mean, I don't even know that there's record of complaints. Again, I think respondents correct, respondents counsel's correct. There's no discipline, there's no record of, this was just an assessment that was made.
Performance issues, nobody saying anything, right? And that could be because of a lack of sort of resources to sort of make those or identify those performance issues.
So again, I hesitate to go too far into sort of my belief, I mean, I could tell the whole story about all of the cases that I investigate, that I invent in my head about what I assume. But that's not what I have, right? That's not,
story.
That's not what I have in the record. And what I have in the record is evidence that they made a decision, a reasoned decision, that this wasn't the right fit, that this job that they newly created could be absorbed into somebody else who felt the person who was doing the job wasn't doing it well enough, and no evidence to support that the decision was based on race. My inquiries are all about, but for her race, would she have retained the position? And there's just nothing to suggest that in the materials that complainant herself provided, and the assertions and the allegations complainant herself made about the work environment.
You called it a reasoned decision a moment ago. Let's there.
So again,
one of see in the record,
right,
that would lead us to draw the conclusion
that it's reasoned. I'm looking for evidence of pretext or falsehood, right? So I'm looking for evidence that they have provided us a reason, of a non-discriminatory reason, that there's not only nothing to suggest it's true, there's active information that disputes it, right? So there's nothing in here that disputes, evidence that she was, that the, praise, I mean, I don't want to talk about what that would look like, right? But evidence that there were performance issues, there's nothing in here to dispute that fact. And there's nothing in here to show that the decision was pretext for something else. So meaning maybe there were some performance issues, but there's evidence in here that that was a pretty common thing. These were, situations that happened with a lot of employees, and it was only the Black employee that was discharged for that reason. So I'm not looking for, I don't step into the feet of the employer to make that employment decision for them. I look to see whether or not there's evidence that it was done for these other, I guess racism would be a reason. Discrimination would be a reason, right? The reason maybe isn't the right term, but there's nothing to dispute that it wasn't a business decision as opposed to a discriminatory one.
What about the timing though? Can't we rely on the timing here? Again, happened during very truncated period of time. We know, right, that timing can be evidence of pretext. I'm curious about, why shouldn't we think about the timing as evidence of pretext at this stage to at least get this case right to a determination that there's at least an even chance that the complaint could prevail at trial.
I mean, you can, I'm not to tell you what to decide based on the case, but in the reading of the record, the final burden is still on complainant to get there. So the causal, that got you through the first sort of phase of there's a prima facie case here, just like that's the causal link, right? I was in this position for a short period of time, this person assessed me in 7 days, and I was fired. But beyond that, there has to be evidence even to get to the 50-50 chance standard, there has to be some suggestion, some evidence that they're either creating a reason to fire her that is untrue, or creating a reason to fire her because they really want to fire her because she's Black. But for her race, she would have retained the position. And there was nothing in the record, as I read it, based on most of the stuff the complainant herself provided. Respondent provided a small amount of information, and that's also another reason why I don't necessarily dig further. Complainant can't provide the sufficient information that I need at the outset. Complainant's the one in the best position to tell me what actions by respondent were discriminatory. If that showing isn't made, then the but-for cause analysis burden isn't met as I determined based on my reading of the record.
I asked you earlier too about information in the record about the racial composition of those staff people in that department. When you narrow the question a little bit further, do we have information about, with respect to adverse employment action that the VP themselves took, seemingly started with the complainant, but what about thereafter? Is there any evidence in the record that thereafter that VP terminated employees, right? And do we know the racial composition of those employees if they actually did terminate?
Yeah, so we always ask for 2 years from the date that people get the complaint. So that would include some adverse actions. I definitely didn't break that down. I'd have to go back to look at, I looked at the information initially to see what the racial composition of the people who were being fired are. So there's some information of that. I don't know that, I guess the answer really is no, we don't really, it's not broken down by who made that decision. So no, we wouldn't know how many people would be fired after or requested be fired after complaint was fired. Or after complaint was fired, so.
What about the racial identity, the individuals who were hired into those jobs, right, that seemingly would have been, that was created after the fired role?
I hesitate to profile based on pictures, and that's all we have. We have a picture of a woman. But no, I think focusing on that, I think it actually goes in complainant's favor. Definitely white people were taking her job duties immediately after she was fired. So, that aspect goes in complainant's favor, but.
Yeah, no, that's helpful. I just wonder, in the absence of any direct evidence, right, of discriminatory animus, we've got to sort of scan the landscape to understand, is there indirect evidence that could get us to a conclusion that there's at least an even chance of prevailing. So that's the piece that I'm struggling here. My sense is that it's not necessarily common. We will see direct evidence of discrimination on the basis of race, and so there's going to be other indicia potentially that would be for the commission.
Right. Always. The analysis for an indirect, that's why we have a burden shifting. She definitely, again, meets her prima facie case. There's certainly the suggestion based on just what happened to her that she meets her prima facie case. Final burden of the analysis where I felt her claim failed. Any other questions?
Thank you, Jane. Right. We've heard from the parties and the investigators. This time we're looking for a finding. There is a motion, sorry. There's one proposed finding.
Your mind.
Barbara. You know what I. Make the motion you want. Make the motion you want to vote for. How about that?
I'm curious to see what you're gonna do.
I didn't mean to put you on the spot. Everybody have some food, get your blood sugar up. Commissioner O'Brien.
I'm trying to find the wording here, go back to it, but I would, move that we accept the investigators report that there is no discrimination. And I need to say.
That's fine. On the record. Okay, do I have a second?
I'll second.
It's been moved and seconded. I anticipate discussion.
I'm troubled by these facts, deeply troubled. I mean, what we've got here is a set of circumstances where a job is created and terminated really within an 8-week frame, right? Oh, 8 weeks, 8-week time frame, right? There's no documentation, performance issues. There's no documentation really at all supporting that there were any deficiencies, right, in his performance. The employer doesn't have a policy in place, and otherwise, there were no progressive disciplinary steps taken. And then we've got, right, 7 days in between when he starts their job and the decision is made and implemented to terminate its performance. Jane, she was talking about the investigation, right? It's true. There's no law that prohibits an employer from making an unfair, right, not reasoned, business decision that has an impact, right, on how somebody puts food on the table for their family. That's really troubling to me. The reality is that that's true, right? And I hope that this is a case that's instructive to employers who are doing business in the state of Maine. There are sort of very basic tenets of, how do you manage a workforce in a way that's thoughtful, respectful, inclusive, non-discriminatory, right? It allows the management team to deliberate, to make and document the rationales for adverse action. So that's unsettling to me. It's also unsettling to me too that here it seemingly we're hearing about additional comments that were made that are not in the record. And understanding, of course, that those comments cannot form, because they're not on the record, cannot form the basis of the decision that we're making here today. I wish, I wish the commission had those comments in the record to help us deliver on this matter. So I'll stop there and turn to colleagues who like to deliver.
So try to be concise. I have a problem with the timeline. I have a problem with the lack of sort of concrete performance issues in the record, in particular prior to this new person being hired. I have a problem with them being fired in 7 days, the complainant. I'm troubled by the job postings that complainant submitted, which it seems very unclear to me as to whether or not it's the same job or not. I don't think, it's just not clear. And if it is the same job, or partially the same job, then that pretty well establishes that this reason that the complainant was given is pretextual. But I just want to emphasize this for everyone. I am profoundly troubled by this incredibly racist statement about complainant's hair that is in the record. And I don't think most of the people in this room or on this broadcast understand just how racist that comment is. For somebody like myself, And for somebody like the doctor here to hear something like that, that is more or less an announcement that somebody is racist. I mean, that comment is, I mean, I'm sorry, but that is, every Black person in the United States understands just how racist that comment is. When somebody says something like, "Where did you put your braids?" That's racist. And so I've got a big problem with this case. I do.
David?
I concur with Commissioner Sanders and Commissioner Douglas. There's a lot missing in the case. Jane says there's no evidence that's submitted in the record, but there's 100 pages that Dr. Scott submitted that said this is the job I was doing. There's no evidence, in terms of no evidence, there's no evidence that that was not the job. And those two job descriptions sound to me like they're the same. I come down to saying I think there's an even chance that she might prevail.
Any other discussions? Seeing none, the motion on the table is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner David?
No.
Commissioner O'Brien?
Yes.
Commissioner Walker?
No.
Commissioner Douglas?
No.
Commissioner Sanders?
No.
Okay, need a new motion.
Yeah, so I'll move that we find that there are reasonable grounds to believe that Green Pages Incorporated discriminated against Dr. Scott on the basis of race, and that conciliation should be attempted.
Do I have a second?
Second.
All right, so the motion is to find reasonable grounds. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
No.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. So the findings are reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and the council confirming the results of the hearing.
Thank you.
And we're at our last case of the extended morning, and that is a housing case, Michelle Luanis versus Franco Properties, H24 0155. There's a recommendation that we find reasonable grounds ×2, and therefore we would hear from respondent.
Morning, Attorney Franco. You have 10 minutes. Do you want to save any of your time?
2 minutes, please.
Waiting all day.
I wish it was morning,
Oh,
but good afternoon. Good afternoon, commissioners. Thank you for your time. So I represent Franco Properties LLC and Frank Reale. One of the things I'd like to say at the outset is it wasn't in my submission, but I think it's maybe the investigator can clarify this. I did not see a complaint filed by the complainant alleging an allegation of the prohibition against having an emotional support pet in the record. I received a copy of the record. In the legal analysis, there's two findings, denial of assistance animals and denial of reasonable accommodation. I did not, and it may be my miss, but I did not, when I requested the commission file, I did not see a complaint alleging a denial of assisted animals. And if you look at the request for information and documents that was requested on it, there were no questions in that relating to that issue. I would respectfully suggest that that issue was moot or not right. Certainly my client hasn't had an opportunity to respond to it other than through me. So there's a due process issue involved going on there as well. But despite that, I will reference the fact that when the complainant filed her application for the rental property, there was a interactive dialogue and discussion between the complainant and the respondent, and he had an emphatic policy against pets. And despite that emphatic policy against pets, the complainant asked that she be provided or allowed to have at least one pet. Didn't make any mention whatsoever about being an emotional support pet or service pet or anything like that, just wanted to bring her dog with her. So, and there's emails in the record back and forth on this issue. And my client capitulated and made an exception for her and said, fine, you can, and it's on the lease and it's on her application, one pet. And she signed the lease and she signed the application, and lo and behold, she shows up on the first day of the occupancy and brings two dogs with her. Makes no mention of the fact that, or allegation that they were both emotional support, which begs the question, and I don't know the answer to this, first time I've ever heard it. How many emotional support animals are you allowed to have under the Maine Human Rights Act? Can you just bring in a pen full? I have no idea. Can they be all kinds of different species and
Assistance animals, so how's it?
no, I'm talking about emotional support. Assistance, I'm sorry, assistance, yeah. So I think the statute's a little unclear as to what, or how many you can have. I'm not suggesting you can't have more than one, I just don't know the answer to that question. But in any event, so the assistance, and it's not clear whether this is an assistance. It's not clear. There's a note that was, and I went through my analysis, that there was an email submitted at some point that a doctor provided a note about her needing the complainant needing an animal. But if you look at the timeline, it was after. It was later on that day. It was like at 12:57 p.m. There was a NASN healthcare letter. And it's not clear. I know that the investigator concluded that the note was provided that day, but it's not clear that it was. My client certainly denies that it was provided that day. He doesn't deny that he received it at some point thereafter. And he also doesn't deny the fact that he allowed both animals to reside with the complainant, and both animals continue to reside with the complainant. So, it's kind of like, you're trying to do the right thing type of thing, even though it's not, there's a lot of technicalities involved in this law, but he's just trying to be a nice guy. He's trying to, help her out. And it's never been an issue. The animals are well behaved. The house is clean. She keeps their house clean. He likes the dogs when he sees them. So it's never really been an issue. It's kind of one of those things. And did he charge a deposit for one dog? Yeah, he did. He didn't know it was an emotional assistance animal when he charged that deposit. It's since been refunded. So that issue is smooth. So that brings us to the parking issue. So again, the complainant signed a lease and it specifically said that no parking would be provided. She could park on the street, and she has throughout the entire tenancy, she's parked on the street. There's a spot right in front of the house. This is a former commercial property. It used to be a barbershop down on Federal Street. Those of you who've been down on Federal Street, Federal Street kind of borders the old cemetery if you go behind there. So it's kind of the house is over here, and the cemetery wall, the high wall there in Portland is to the left of that. So it used to be a barbershop. And when it was a barbershop, the barber at the time, 40 years ago, used that area for customer parking for himself. So when my client bought it in the 1980s, he wanted to use it as a yard for the apartment building that's next to him, because he has a 3-unit next to him that has kids and all that in that unit. So he thought it'd be nice, especially in Portland, there's not a lot of green space downtown. So, grassed it over, used it for a yard. And that's the way it's been. And so, you know, fast forward to this tenancy, she agreed that she didn't have parking. So she could park on the street all day long, all day, every day, all night, every night, all week, every week, all month, every month. Except, you know, when the winter came, sometimes there are parking bans and you have to keep your, you know, you have to put your automobile in a public parking lot or else it's gonna get towed. So that's where it comes in the report about those months that he said, well, you can park on the side during these months, because that's what she asked for. Initially, it was, I just want to be parking next to the house here. I can't park on the street because of the winter parking ban. So we said, fine, you can use it during that. In other words, he gave her what she asked for. And then it later became an issue that it was going to be the whole year. That's all I have for that. Happy to answer any questions.
Commissioner, questions for Attorney Frank? Commissioner O'Brien?
Thank you. In the respondents interview. Okay, I'm looking at page 6.
6 of the report?
6 of the report.
Yep, okay.
The summary.
Yep.
Complainant called them assistance animals, but they are not assistance animals. So can you speak to that? That to me, I'm sorry that he didn't know what assistance animals were.
Yeah, he might have been confused the difference between having a service dog and an emotional support animal, and sometimes those terms get merged. But he'll be the first to admit that this is the first time he'd ever encountered a situation where a tenant of his wanted to bring a pet in. It's the first time he's ever made an exception for a tenant of his. So she basically doesn't matter to him whether they were or not. He just said, you can keep your pets.
Okay.
But they weren't pets, right? So
Well,
So
again,
when-
I'm just going by what
Yeah.
happened, not this hyper-technical statutory language about, I understand the distinction between a pet and an assistance. You don't have to talk to me about that, I know that, but my client at the time.
So when, it's a little bit murky in the record for me, when does your client allege he was first put on notice that the complainant's animals weren't pets, right? That they were assistance animals?
At some
When
point,
did that know?
he's not sure. Okay, at some point he received the note. Okay, he's not saying he never received the note. He's saying he didn't get that day, even though it's dated that day. But there was never any, discussion other than that note. In fact, has never been a discussion between the complainant and the respondent about these animals, other than that note. So he said, fine. It was, well, okay, fine. I get the note, fine. Everything's fine. He didn't know anything about the deposit issue. Who's gonna know anything about that unless you know how to get to the statute? No one's gonna. It's not a. That's kind of a nitpicky point. It's an important point. Don't get me wrong. You're not supposed to charge deposits for assistance.
Yeah, I agree, right, not a nitpick, yeah, point, to the extent that you're.
Well, it is to someone who doesn't know.
Well, but I think I heard you say that your client owns properties, right?
He owns that one and he owns the one next to it. It's 2 buildings. One's a 3-unit, one's this one. That's it.
Yeah, and sure, and I guess my point though is that, the law's clear on this.
Ignorance of law is no excuse. I'll be first to admit, I agree with you on that. Okay, I'm not suggesting it otherwise. But it was just never an issue until this case, and it wasn't even part of the complaint. So that's if someone could show me the complaint, I'll defer. All right, I may have missed it. I'm the first to say I may have missed it.
Yeah, Commissioner O'Brien.
Wait. You're saying it's not part of the complaint?
No,
Yes.
it's not.
Hang on.
I can answer this question. So it was not, the assistance animal complaint was not part of the initial complaint. It was brought up in later documentation. There was no formal amendment of the complaint, but respondent was given a chance to address it. It was investigated. We do this routinely. The reason that respondent does not necessarily know about what was in the record is because my understanding is they were in a non-disclosure agreement, so they would not have been sent those communications. That's what I have heard from the investigator. That's what I recall from reading the record. I'm sure Alex will correct me if I'm mistaken.
So, okay.
Any other questions for Attorney Franco?
Yes, Attorney Franco, good afternoon. Work has been here all day.
So good.
I just want to make sure that I understand the timeline on the parking issue.
Yeah.
So the plaintiff signs a lease, she moves in early February, right? And then it's your contention that there's no request for a reasonable accommodation until like November. Right, okay. And then after the request, because I know at some point your client says fine, she can park there, right? When did that happen?
I think it was, he said that, yes, okay, I'll make it available. And then he had to hire someone to actually turn it into a parking lot and take the fence down and all that. That's been done, but that I'll be the first to admit, and my client will be the first to admit that he could not do it himself. And with the, trying to get contractors to do work, it was only done recently. So, but there was no, so I can't give you an exact date.
But he did tell her that she could park in the yard from December 2023 to March 2024. That's in your statement, right?
That was her initial request because of the parking ban issue. And then he later said, and later expanded that and said, I'm not gonna put a restriction on the months, because she changed, she made one request, but just the winter months, and then she says, no, I want it all the time. So every time she asked for something, he gave it to her.
And this is the December 9 text here.
Right.
He says, you want to park there year round, you can, but you gotta shelf yourself out.
Yeah.
Right. Okay.
Yep.
Any other commissioner questions for Attorney Franco? Okay, seeing none, you'll have 2 minutes when we come back to you.
Thank you.
Ms. Blanes? Unmute yourself. Still muted. Okay.
Good afternoon.
You have 10 minutes. Do you want to save any of that time?
Yes, 2 minutes, please.
All right, whenever you're ready, go ahead.
As far as the dogs go, I was homeless prior to moving here. Unfortunately, Mr. Rielli, I got this, I'm so sorry. I got from housing, they said, oh, we have a small place for you. And I spoke with Mr. Rielli right away. And it was great. It was like amazing, because almost 2 years I was homeless. And the dogs, it's so hard because it goes back, because the reason why I was homeless, was because my name wasn't on a house that I lived in. I've never lived in an apartment, excuse me. I've never lived in an apartment. I've never lived in the city. I've only just had horse farms. This is new to me. I've lost all my animals and everything. And so I'm an elder woman. I do have my 2 dogs left. They are very important to me. That's the only thing keeping me alive right now. Excuse me. So when I had the dogs here, he forced his way into the house. He came to me and told me what to say here with the commission. He told me what to say the other day when he put in the driveway on, I believe it was Friday. Yeah, he forced his way in and.
Hang on a second, Ms. Luanis. I think the investigator is telling me that that is not on the record. So I'm going to ask you to refrain from speaking about that.
I'm sorry, dear.
Okay.
All right,
So
it's police filed.
Yeah, it's not in the record, so we can't
Okay,
discuss.
no problem. Then we won't talk about the dogs. We'll talk about the driveway. I've never parked in the city. He never expressed that I had to move my car on certain nights so they could clean the streets, and there was a parking ban in the winter. I don't know, call me dumb. I've always had a driveway. Yeah, he's not the nicest man. He's been very cruel to me. He never told me he was putting in a driveway. He told the new tenants next door. The children moved in, I believe in June of this year. Otherwise, there were no children here. There is a very large backyard, as well as, I don't know what he meant by recreational in the front yard. No one used the yard but me and my two dogs. I have one dog that is very old, and I have another dog that is younger. So they're very important to me because I know one's gonna pass away soon. So as far as the driveway, I'm moving on November 15th because I can't take it anymore. I can't take the harassment from his tenants next door. I can't take it from him anymore. I just can't. I have to leave. I'm going to Massachusetts. He told me to say, I know it's hearsay, so I won't say that. But his wife came here. He came here a few times to tell me to say what to say. But I just I don't want him to be hated, but I want him to know the only reason why I did this is because I asked him, are you going to let me park in the driveway, which he calls a yard? And he said no. Finally, he said no. And I said, okay, I have to do something about it because I have COPD and it's progressing. It doesn't go away, so I'm getting sicker. I'm on oxygen. I have a sleep apnea machine. I have my nebulizer. I'm doing the best I can. I keep all the property clean. I have upgraded the property. I have a broken toilet seat that I've had since June of last year. I'm talking broken, that I have to sit on. I have a heating unit that it just has one heat. It has one temperature and it melts everything in my home. So I have to keep a fan on it. And I told him about it. I said, can I replace the thermostats? And he said no. So I'm trying. I was going to put gravel in the yard. I would have paid for it. My sister would have paid for it. I've had to go to New Hampshire a lot during the winter because of the parking bans. I can't stay here. It's too expensive to move my car. I don't mean to be upset, but I am. This has put me into a lot of crisis. He has put me into a lot of crisis mode. But I guess I don't know. I came to you because I had nowhere else to go. And I feel he knows what he's doing. He's been a landlord a long time. He does not respond to me. He responds to the new neighbors or the apartment next door. He will not fix my toilet. He came in here to fix my toilet seat. I showed him the new, because I broke it. I broke it. I stood on it to fix my curtain and I broke it. And I went out and bought a brand new one, a better one, a soft close so it wouldn't slam down. And it's still sitting in the box. A year ago, June, I had no sink in my bathroom for a whole summer because he said it was too hot to fix until the fall. I mean, this is just constant. So I have to leave. I have to leave. Unfortunately, because now I have a beautiful driveway and a place to park my car and I feel safe. And now I have to leave. So that's all. Thank you.
Commissioner questions for Ms. Luanis? Commissioner O'Brien?
Well,
yes, yeah.
thank you. I have two questions, but I'll space them out. One is, if it's in the record, it speaks in a footnote that you tried to withdraw this claim.
Because he came to me, and I'm frightened of him.
Okay, that's okay. Thank you. That's all I needed about that.
Did you have another?
Yeah, well, no.
Okay. Okay. Any other commissioner questions for Ms. Luanis?
Okay, then I was gonna, you got it.
Yes, please.
Okay, could you explain, or one of, in regards to the parking issue, it's alleged that you read them and initialed each page saying there was no parking. Do you dispute that?
No, I do not. But I didn't know it was going to be so difficult.
Okay.
I didn't understand. I'm sorry.
Okay.
And I was homeless. What was I to do? You know?
Okay. Yes. Okay. Thank you.
Thank you, Pam.
Any other commissioner questions for Ms. Luanis? Seeing none, I'll have about 2 minutes when we come back to you. Attorney Franco, you have 3 minutes.
I don't know if I can handle this.
Thank you. I would point out there was a lot of statements there that were not in the record about communications between the parties, and
I did address everything that the investigator told me.
anyways, this issue about, I think if my client should be commended for the fact that he didn't claim undue hardship. He didn't give it, he didn't, refuse to put a parking spot in. He could have very easily said, it's a recreational space and you can park on the street and there's no issue with you parking on the street. And if you, in fact, that's where she parks 99% of the time anyways. Yes, there are times when she has to move the car because she lives in the city. And that's when she had to move the car to a space to allow for the no parking ban to become to effect. So, and that was the reason why she asked for that initial period of time. But, my client just did not allege undue hardship. He said he was going to do it. He's done it. And, it's too bad that she feels the way she does about it. But, she at the outset, she said it was a blessing or whatever she said about my client giving her the apartment to begin with, but she was homeless for 2 years. So, it doesn't make any sense for someone to express the compassion that he did over this complainant and then turn around and try to discriminate against her. It just makes no sense. In fact, there's no evidence in the record of any intentional discrimination. And I would respectfully disagree with the issue of this denial of assistance animal issue as being ripe for discussion because just because it got brought up during an issues and resolutions conference, he was never on notice that there was a claim for discrimination based on that. You know, and the fact that he didn't sign an agreement of non-disclosure doesn't nullify the requirement that he be put on notice. And he wasn't put on notice, and it shouldn't be part of the record. Thank you.
Commissioner questions for Attorney Franco? Commissioner Douglas?
Yeah, I just want to come back to the timeline on the parking, and I'm looking at the report now. And I just want to make sure that we all agree that this is the time, right? So from your perspective, a request for a reasonable accommodation was made on November 3rd, right? Do you agree with that?
Yes.
Okay. And then on November 16th, your client, well, I'm sorry, November 3rd, you actually get the letter from the physician saying you need a reasonable accommodation. On November 16th, then your client says that you can park in the yard from December to March, right? Is it your understanding that complainant did actually park in the yard during those months?
I don't know if she did or not. I know that she was told she could. And I don't think the commission, I mean, the investigator ever said that she didn't.
Okay.
I don't see anything in the report that indicates that she didn't park.
It's your position and your client's position that she was permitted to.
Yes.
During those months.
Yes.
And then December 19 text that we discussed earlier, where your client informs the complainant that he's thinking about letting her park in the yard, did not expressly grant her request, right? And then in May, your client decides to pay the yard.
Right.
Right? But that required some work.
Right.
I think you in your initial presentation, you said there was delay there due to contractors and so on and so forth.
Right.
How long is the period of time where she can't park there due to the construction? You know?
No, I don't.
Okay.
I mean, I don't necessarily agree that it says respondent's actions created a long delay wherein complainant could not park in the yard.
Right. That's what I'm trying to get to.
Yeah, I mean, why, listen, so common sense, right? In May, respondent decided to pave the yard and then told the complainant that it wouldn't be done until October. Does it belie common sense to suggest that my client said, oh, and by the way, from May to October, you can't park in the yard?
So I think the question is then, has this construction now taken place?
It has.
Paving? When did it take place?
It didn't take place until last week, is my understanding, October. Well, it was supposed to take place in October. It took place in September.
And how long did it take?
Couple days.
Couple days. And in the meantime, was complainant told that she could not park in the space?
I'm not aware of that. I don't think there's anything in the record. Other than that statement, created a long delay wherein complainant could not park. The investigator did the issues and resolutions conference, and I'll, if she wrote down a note that I haven't seen that said that she couldn't park there that period of time, then again, I wasn't there. But, the other thing is, my client wanted to help her get a handicap parking spot out front. And she said, no, I don't want it. I want to park in the yard. So at some point, there has to be some reasonable action. Yes.
Thank you. Again, two questions, I think. If it's in the record and it was mentioned, it's been mentioned, you've mentioned several items that the respondent was not aware of, and the reason was and a refusal to sign the NDA. What is the reason that didn't happen? That he did not sign an NDA?
He's not a sophisticated individual when it comes to this. And the first thing that I did when he came to me is, I can't get this record without you signing the NDA. He goes, what's that? So, I mean, I can't, if he didn't sign it because it really wasn't explained to him as to what the significance of it was. Should he have gone to a lawyer right away? Absolutely. I don't know what the frequency of people not signing that document
But
is.
so when you said that to him, is there an NDA signed now?
Yes, I got the file from the commission. Yes.
Okay.
We can.
Absolutely.
Happy to discuss the procedural aspects of this once we've finished hearing from the parties.
Okay. Oh, okay. We get that. Thank you.
Further questions for Attorney Franco?
Can I mention one thing now? Thank you.
All right, Ms. Luanis, and just so you know, it looks like you're recording, which is fine if you want to. This is being live broadcast to YouTube where it will be available in perpetuity. So you don't have to do this.
Okay, dear, thank you.
Yep. You have 2 minutes and 15 seconds.
Okay. First of all, I had to sign something that Frank Reale brought to me, and it wasn't reasonable for me to sign. So I refused to sign it. It was just a document he made up, like not to kill the children or run them over. But there were no children anyway, so whatever. And he did this to me twice. He had brought forward this clipboard and, oh, you got to sign it. Or I've not parked in the driveway until Friday of last week. They finished the driveway in less than a day. It's gravel. So I parked there since Friday. He would not open the gates for me to park there. No. And this is the old port. There is no parking on this street in the summer. There is no parking on the street in the fall. You leave. I don't get to leave my house. I am a shut-in because if I drive away, I'm not going to be able to park when I come home. And also, I had the man come. I know I thought I put the message he sent me, the man that takes care of the roads in the city. He came and measured the spot and said it isn't reasonable for two handicapped people to depart their vehicles. There's not enough frontage. He measured it. I saw it. My neighbor saw it. And that was it. I called him. I said, you have a report? He said, speak to my lawyer. So that's where I am with that. That was not a refusal. That is no way. I called without Reale. He never told me about it. I told him about it. And then he said, I said, no, I wouldn't take it. Of course I would have. It would have been for everyone, but it would have been more likely I would have had a parking spot and been able to leave my home.
That is your time, Ms. Luanis.
Yes, dear.
Any more questions for Ms. Luanis? Okay. Seeing none, we've heard from the parties, and now we'll hear from Investigator Brindley.
Hello again, everyone. Good afternoon. So I want to go in the order of the claims as they're written in my report. So first would be the denial of assistance animals. Now, Attorney Franco has stated that his client was not made aware of that claim. As Barbara stated previously, respondent was made aware. I interviewed the parties separately because respondent refused to sign the NDA, which I can touch on later. But I did ask him if complainant informed him that they were assistance animals and whether that was accommodated. In response, he said that he thought she lied about being assistance animals. Now, respondent didn't provide anything, in paper responding to that allegation. I do have in the file a letter from complainant's doctor stating that her two dogs are emotional support animals or assistance animals in that regard. And there were some emails back and forth between the parties regarding the fee that was imposed on Miss Luanis for her two dogs, which she asserts are assistance animals. Respondent denied, stating that they were lying, but it seemed, based on the evidence that was provided, that he was informed that they were assistance animals and the fee was still imposed. In regards to the NDA, very quickly, I asked Mr. Reale to sign the NDA many times. During my interview with him, I told him that if he did not sign it, we couldn't provide him any of the supplemental information provided by the complainant in this matter. He, again, decided not to sign the NDA, but that's neither here nor there. It just shows that he, could not respond, I guess, to every single thing that the complainant provided, but he did respond to the claim of the assistance animals and next, the denial of reasonable accommodation. So moving forward, complainant in fall of 2023, there's some factual dispute as to when complainant made her original request for reasonable accommodation in regards to the parking lot. However, she did, as she stated previously in her presentation, she did provide a screenshot of the voice recording from the city doing the analysis for the parking, or like creating the disability accessible parking space in front of the building, stating that simply there just wasn't enough frontage to input, an accessible parking spot there. And that was in August of 2023. So based on that, it was the assumption that she had made the original request earlier than August of 2023. She didn't provide her doctor's note until November of 2023, wherein she requested to use the parking spots and was given the ability to do so December to March. During her interview and any supplemental submissions that she provided to the commission, Ms. Valandis made it clear that the reason she needed to park on the driveway or the lot next to the building is because, number one, the parking in front of the building is not assured to her. And if she can't park in the spot in front of the building, she would have to park much further away. And due to her disabilities, walking and therefore breathing is very difficult. And she'd have to get home and call someone to take her back to her house because she couldn't breathe. Yeah, and then there's the interim space where respondent allowed her to use it and then didn't allow her to use it. At some point during the investigation, Ms. Valandis stated that she wasn't allowed to park on it after that time. But yeah, it seemed that the timeline between November, if that is the very first date we're looking at, to March, when the respondent states, yes, this is actually what we're going to do, that delay of the reasonable accommodation process seemed sufficient enough to create a denial of reasonable accommodation. I'm open to any questions, should you have any.
Commissioner David.
Alex, I think you just said this, but I just want you to remind me again. Did you say that respondent told you that she had said that they were assistance animals?
Yes. He said
no question about that.
She lied about them being assistance animals.
Oh, he knew that she said it, and he just said that she lied, and there's no indication he made any further inquiry. Any indication that he knew that he couldn't charge a fee?
I'm unaware of his knowledge of the law, but
Yeah.
the law still applies regardless.
Yeah, but he wants us to conclude that he's a nice guy because he reduced his illegal fee twice. Isn't that the state of it? Yeah, okay. Thank you.
Commissioner Douglas.
Yeah, I'm just curious about, I keep coming back to this parking situation, right? Because it seems like there are a series of communications from the respondent where he says, you could park here, you could park here, park here. And then there's this period of time alleged where the complainant cannot park there. You reference a sort of a lengthy delay in your report. And my question is, what is the source in your investigation of this information about complainant not being able to park in the spot? Is it just from complainant, or is there additional evidence?
considering the fact that the respondent didn't sign an NDA and the fact that he didn't provide much supplemental information, the majority of the evidence that was provided to me during the investigation was from the complainant. In this case, Ms. Luanis provided multiple pictures of Mr. Reale parked in the spot that was allotted to her next to the building, stating that she couldn't park there. So I thought that was telling.
Okay. And do you have a sense as to when those pictures were taken?
I mean, I could pull them up. It seemed to me that they were taken the day of and sent right to me. So if I look at my documents here, I have some in June, a couple in June, some early July.
Thank you. That's very helpful.
Thanks.
Any other commissioner questions for Investigator Brindley? Seeing none, we've heard from the parties and the investigator. Commissioner David.
I'm ready to make a motion. I move that we take them together, and we find that there are reasonable grounds to believe that respondents, both of them, discriminated against a complainant on the basis of disability and on the basis of denial of reasonable accommodation.
I could second that. Okay, it's been moved and seconded. Any discussion?
I just want to say that with Ms. Luanis, you presented this pro se me with no attorney, and I think you did a very good job.
Further discussion? Seeing none, the motion is to find reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner Bryan? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders? Yes. Findings are reasonable grounds. We appreciate everyone's participation. The commission will send a letter to the parties and the council confirming the results of the hearing. And now, this
And
time.
since you guys got to eat lunch and I didn't, I'd like to go ahead and make a motion to go into executive session. Is that all right?
Great. That's fine.
Promise it won't take long.
Okay.
Pursuant to 1 MHRC section 405(6)(e), I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Second. Right, if you are in favor, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders? Yes. We'll pause for a moment while we figure out the tech stuff again. If anybody wants to run out for a moment. Ed, I'm going to invite you to a breakout room.
Right.
Yeah.
Little,
Which is right through the little
flowers.
Yeah, and then we.
While you're here.
Not quite. Can you mute us, Chelsea?
Yep.
All set. Commission's on mute. I've got that motion if you want.
Unmute. Okay, can you hear us?
Yes, I can.
Okay, great. Then go ahead with that motion.
So I will move that we not litigate the case of Halliday versus Connectivity Point Design E220139, nor the case of Goodwin versus Beckert E220206-A.
All right, if you are in favor, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Great.